All right. Morning.
Good morning, Your Excellency.
So just to be on the safe side, today we're going to have Mr. Saliba again. Sorry for trouble you over the weekend to come again and talk. For how many? What? 40? How many? How long
I would estimate an hour.
And an hour? We're going to break at 11:30 anyhow, but then you will continue with that? 30
yes.
minutes?
Then after Mr. Saliba, the defendant will call their witness, Mr. Khatib. My current estimate is about half a day, maybe two to 3 hours, something like that. So I have told my industry expert, Mr. Yusuf, that he needs to be available this afternoon. So we would hope to move on to him this afternoon.
We'll break at 11:30, then 1 o'clock, then back again to 2. So
Would it be worth breaking after we finish with Mr. Saliba, perhaps?
Yes, sure, absolutely. Thank you. So let's start.
Good morning, Mr. Saliba.
Good morning.
Now, on Friday, we were looking at the first half of your statement. The second half provides a number of what you refer to as key assumptions that underpin the hypothetical revenue and costs in this case. Essentially, you are providing data on which the experts can model what would have happened. That's what you're doing, isn't it?
Yes.
But that data is, as you put it, key assumptions.
They are key assumptions based on actuals.
Well, you say actually that your key assumptions were based on your experience of other TPA agreements.
Yes, it's based on data collected from all our operations, because our TPA model is practically the same amongst all our operations.
But those other TPA agreements would have been in other jurisdictions, other countries, wouldn't they?
Yes.
In other markets.
In other markets, but mainly all our TPAs, we operate in the Middle East and in North Africa. So
This case has proceeded on the basis that different markets have very different characteristics. That's why we have a market expert. Is it really the case that other markets would have the same conditions, could provide the key assumptions on which you rely?
there are some similarities between this market and other markets, and there are some differentiation. This is why every country has its assumption based on our know-how, our key assumptions, our actual data, and model to suit the local territory.
And the other point I wish to draw in respect of an assumption is it is essentially a matter of opinion, isn't it?
No, the assumption is not an opinion. It's based on the actual data that we have from our long-term experience in the TPA market. GLOBEMED operates in the market since more than 30 years. So we have all this, our data bank and our database, which allows us to give a very precise information and forecasts.
But to the extent that you assume or you forecast by reference to the circumstances in another country, that inevitably involves an element of opinion, doesn't it?
Sorry, excuse me, but
You've used the word forecast, you've used the word an assumption. You are essentially using data from other countries, other markets, and assuming that they will apply in this market.
no, we are using our experience from all our markets and our experience in Dubai, and to model a forecast for the local operation.
You could have used the illustrative forecasts in the MOU, in Annex 2, couldn't you?
Yes, we could have used it, but we had to adjust some of the figures in this MOU. Practically, the data in the MOU is more or less in some areas similar to the forecast that we have put, that we have given to the experts. There was some adjustment that we had to do mainly on the, when we have received the actual figures of OIC, because when we did the the projections in the MOU, it was back in 2015, and it was based on a number of members that were given to us by OIC. And when we appointed the expert to do this loss of profit projections, we were given by OIC their actual numbers. So definitely we had to adjust the projections.
Well, Mr. Burrows has adjusted the MOU, and his figures are based on adjustment of the MOU. You, on the other hand, say that the disparity of number of lives was, in your words, so significant that the Annex 2 forecasts are irrelevant. That's your word.
No. What Mr. Burrows made, he based his assumptions, he based his forecast on the assumptions of the MOU. What we did, we adjusted what we had done in the MOU to suit better the actual figures that we had. But in every terms, if you take some of the cost projections in the MOU or in our model, in our expert model, or in Mr. Burrows. For example, if we take the personnel cost, which is in the TPA, makes the bulk of the expenses and is the most sensitive on the bottom line of the TPA. If we keep everything equal and we put what are the differences in the revenue assumption, for example, if Mr. Burrows had included the BUPA lives, and Mr. Burrows had included the non-IC business, if Mr. Burrows had included the 4 years contract instead of 3 years contract, you will find out that the HR cost in Mr. Burrows and in the MOU and in Mr. Kotel report will be more or less the same.
I'm going to ask you, Mr. Saliba, if you could limit your answers to answering my questions rather than giving lengthy speeches. We'll be much quicker if we proceed.
I will try, but this one was a little bit. I had to explain it further.
That was my advice earlier. Just sometimes.
Your Excellency, I will try to limit, but this is quite essential, and I had to make this clarification.
I'm grateful.
Thank you.
Could we look at D342 quickly?
Okay.
I'm looking at, first of all, paragraph 79 is your reference to key assumptions, and paragraph 80, if I could pick up the final two sentences, the number of lives administered by TP is of fundamental importance as it informs the entire operation, in particular in relation to the level of staffing required to administer those lives. In other words, the difference between the illustrative forecasts of the number of lives appended to the MOU and the actual number of lives disclosed is so significant as to render those illustrative forecasts irrelevant.
Yes.
That was your approach at the time. I think you're suggesting now that actually adjustment of the MOU may be a better approach.
No. This is not what I have said. What I have said is typically what is in this clause. This clause, we are saying that the difference in the number of lives that were communicated to us after the fact were we had to do a new forecast in the actualized data, and the TPA business is highly sensitive to the number of lives. This is the same what I was saying.
And you recall that the MOU predicted, I think, 415,000 lives in 2015?
Yes, this was based on information given by OIC team members. They were forecasting for 2015 415,000 lives.
Clarify, in terms of the data that feeds into Annex 2 of the MOU, the model, essentially OIC provide the number of lives, but almost all the remaining information came from Mr. Tomey, didn't it? It's Mr. Tomey who carried out the modelling exercise.
Mr. Tomey, in his capacity of the general manager of GLOBEMED Gulf at this time, and in his long-term background in the TPA business, and as an actuarial, he did the modeling, and I was reviewing with him, same as OIC were reviewing with him. The model that was prepared by Mr. Tomei, reviewed by myself, was shared with OIC, mainly Mr. Purigitina Taldena, who was the Vice President Finance for OIC, and his assistant, I assume if I remember well, it was Mr. Kalash, and they gave their opinion on these projections, and there was a lot of back and forth between OIC and GLOBEMED to reach the final projections at that time.
If we could turn on to paragraph 86 in your statement, which is at page 344. I want to just refresh your memory. So, after a prediction of 415,000 lives in January 2015, we're now in February 2015, and the projection has by now dropped to 357,000 lives, if you tot up those numbers. So in the space of a month, there's been a very significant movement in the numbers.
Yes.
And I believe Mr. Cottle believes the actual figure for 2015 was 332,000 lives.
Mr. Cottle report was based on the actual data that was provided by OIC after the fact. But what was done in the MOU was based on the projections, on the projected lives that OIC were supposed to enroll during 2015. When we did our projections, we took the number of lives. We were doing this negotiation around November, December 2014. And in that time, any insurance company, mainly large insurance company, they have the full year projection. They were doing their budget. They knew what they were. They knew what they had. So they had a projection of their premiums, which affects the amount of claims, and they had projections of the forecasted or targeted number of members that they will enroll in their business. Based on this data, we did the projections of the TPA. So what happened later in 2015, I don't have any information what happened at their level, which led to a drop in their number of lives.
I'd suggest to you that the reason these numbers are so volatile, dropping from 415,000 one month to 357,000 the following month, as we've seen in paragraph 86, is because there's a significant element of churn in health insurance.
Excuse me, element of what?
In terms of clients, employers, changing insurers on a regular basis where they feel they can get a better rate or better providers or whatever it is. There's a high element of change in the market. There's very little inertia on the part of companies, employers, and customers.
I'm sorry, this is your suggestion. I'm not in the insurance business. I cannot talk on behalf of insurance companies. We are in the TPA business, so we service their portfolio. So I'm not in a position to explain why OIC had this drop.
You're not even curious as to why the estimate goes from 415,000 to 357,000 in a month?
I don't think that the drop was from 415 to 350 in 1 month. By the end of 2014, they had around 380, but they projected for 200 to reach by the end of 2015 415,000. So it wasn't a drop from 415 to 350. Anyway, the insurance company, if you want my curiosity, usually the insurance companies, they have market strategies, and any insurance company, they have approach to the market to either have a better performance, to decrease their loss ratio, or to be aggressive by decreasing their premium and getting more market share. So, but one more time, I cannot be in the shoes of an insurance company and analyze their performance.
Well, they were both projections, weren't they? The January figure in the MOU was a projection, and if we look at 86, a projection by OAC, If we look at paragraph 86, that too was a projection in February, a month later, also by OIC.
Yes.
Very high degree of volatility in terms of number of lives.
It can be. It can be. It's.
Okay, can we move on and examine a few of the items on which you offer assumptions? We start with administration fees. You recall, we may need to turn it up, we may not. Do you recall Appendix 7 to the TPA, which sets out a structure, essentially a fee structure?
The fee structure of the TPA fees that OIC was supposed to pay to GLOBEMED. Yes, I recall this. I recall this very well.
And actually, if we look at, I think it's page F1 2080.
1 minute, please. No, not this one. No, not this one. This is not the fee structure. If you scroll down, yes, this one. Your,
Do you want to give me the page?
It's 2081, yes?
Yes, but before we get there, if we could just go back to 2080.
Okay.
You see there the explanation of scenario 1, which applies if basic lives are less than 20%, and scenario 2 if basic lives are more than 20%.
Yes.
And then if we go to your page 2081 over page,
okay,
we see that there are different, well, firstly, different fee structures for each of those scenarios, and then within each scenario, there are different slices of non-basic lives. And so the number of lives is critical, isn't it? Because if you get the number of lives wrong, that can affect which scenario you're dealing with. It can affect which slice you're in. It can affect which per capita fee. And it can affect the number of lives that are paying that fee. So there's a real risk, if that number is wrong, that any error is likely to be compounded.
If I may correct you, the difference between the two scenarios is only on the basic plan. It's the fee for the basic plan. The two fee structure, scenario 1 and scenario 2, has the same minimum and maximum, and they have the same bracketing in terms of number of lives. So they are completely identical, except the fee for the basic plan. So what affects the work of a TPA definitely is the number of lives, but also it affects the number of claims that will derive from these lives. So if in a scenario where we have a higher number of basic plan, so this is why we put this scenario 2. If the number of lives will consist of a higher than 20% percentage of basic plan, so we were concerned about having a big number of lives, having a lot of cost, and getting a minimum fee. This is why we have put a higher TPA fee for the basic plan if the number of basic plan would increase more than 20%. There is this synergy between all the plans in a TPA market. And by the way, this fee was not the standard TPA fee. This fee was imposed on GLOBEMED by OIC. So we accepted this fee. We had a concern about that this fee will not render the TPA highly profitable, mainly in the year 1. This is why we had to do the projections that were appendix to the MOU to make sure that this fee, which is a reduced fee compared to the standard market at that time, and to make sure that the TPA will not be a loss-making. Sorry for the long answer.
Well, you just sought to give essentially further evidence about a reduced fee. There's no suggestion anywhere in your statement or anywhere in the documents that these fees are in any way reduced. New evidence, isn't it?
This is not a new evidence. This is evidence that is in the numbers. The 33 million fee, this magic number of 33 million, if you take it, the TPA market usually, the TPA charges and administration fees as a percentage of the premium. And sometimes it is a fee per capita, but most of the time it's a percentage of the premium. The percentage of the premium at that time for TPA market was as a price list between 7 and 8%, and usually TPA, they used to give discount for volume for large insurance companies. This discount would reach the TPA administration fees at around 4% after the discounts. But this 33 million, if we compare it to the amount of premiums that were serviced by OIC, that were written by OIC and was supposed to be serviced by GLOBEMED, would render the TPA fee merely around 2%, which is 50% less than the discounted market in 2015. So this is what I said, what I meant by reduced fee. And I reiterate that this fee was imposed by OIC. This is what they tell us. This is what we are ready to pay, whether you take it or not. But we took it.
My question was really rather short. It's whether there's any evidence that this is a reduced fee. And there is no evidence this is a reduced fee.
There is an evidence. The evidence is that if you take the 33 million...
I don't think you need to give the speech again.
Okay.
Well, let him answer. If you're going to answer the question again, you've got to let him answer the question, unfortunately.
You want to answer the question again?
Yes, definitely. If you take the 33 million fee, if you take it as a percentage of the total premiums written by OIC, it will render around 2%, whereas the market at that time was around 4%.
As a CFO, this model would have given you some concern, wouldn't it? Because it's obviously volatile.
Yes.
Could we look at the ramp up? Your understanding, again your word, was that the whole portfolio was to be transferred by the 5th of January 2016?
Can we go? Is there any page?
Sure. If you want to look at it, I think that's in paragraph 88 of your witness statement.
Which number, please?
Sorry, paragraph 88, page D344.
Yes.
That's right.
Yes.
You've checked it.
Yes.
Now, the reality was there was no contractual provision as to the transfer of BUPA other than Article 15 of the MOU, was there?
The contractual provision was in the exclusivity clause.
But there was no promise that BUPA lives would be transferred.
What do you mean by promise? There was an exclusivity clause that GLOBEMED, as a TPA, will service all OIC portfolio, with the exception of that we have discussed last day, in the case of any client would insist on having another TPA. But the commitment of OIC was to get the exclusivity to be serviced by GLOBEMED TPA. And this is why they have put the BUPA clause, because they were committing for exclusivity, whereas they didn't get yet the green light from BUPA.
So that was the uncertainty from their perspective as to whether BUPA would give the green light.
If there was this, yes, definitely there is always uncertainties.
And that was why OIC had sought the protection of the BUPA clause.
They have sought a protection for something that they are committing for without getting the approval of this client.
Can we move on to volume rebates? These were purely discretionary, weren't they?
No.
Well, the provider at the end of the year decided whether they were going to give a rebate based on the amount of treatment or the number of lives referred to that particular provider.
No, it's based on the volume of claims that were treated at a specific provider, and it is mentioned in the provider contract. The provider contract, there is the tariff, the volume discounts, sometimes there is a specific arrangement for large claims that we call jumbo claims, and on top of this, there is volume discounts, which aggregate all the claims received from different insurers for a basic TPA, and the provider will grant volume discount to the TPA.
In many cases, the provider agreed a volume discount after the event, didn't they, at the end of the year, as an exercise of discretion?
No. The provider agrees on the volume discount in his contract. So the volume discounts are defined, clearly defined in the contract. Usually they are by brackets. It's an increasing bracket. This is why when we were talking about the strategic partner model, as much as the TPA will grow, as much as all its clients will benefit from this synergy.
When you say in your witness statement it was intended that GMGHS would seek to improve the rebate terms, you mean therefore that they would be renegotiating the agreements with the providers?
Yes.
That would inevitably take some time, wouldn't it?
Sometimes it takes some time. We didn't project to have this renegotiation to be accomplished soon. We gave at least 1 year to finish from that. The fact is that, which was controversial at that time, is when we looked at the volume rebates that were obtained by OIC, they were in a percentage-wise much lower than the volume rebates that were being able to be collected by GMGHS, despite the fact that OIC had a larger number of claims than GMGHS. But from another point of view, OIC, they had better tariff than GMGHS. So the intention was to use the best of the two contracts, and this was in one of the communication between OIC and GLOBEMED at that time. I don't remember the exact date of this communication, that we were supposed to use the best of the two contracts.
And you say that you could have improved the rebate terms by taking an aggressive approach to negotiating. Is that how you would improve them over the course of at least a year in renegotiating with the providers?
Yes, because when I have a very small book of business, and I can get on average a 2% in volume rebates, what if I will be negotiating with the same provider with a much larger book of business? Definitely, I would have been able to get a higher volume rebates and better terms.
So the improved negotiation results from the larger portfolio, not from an aggressive approach.
Using the large portfolio and approaching the providers.
So without that larger portfolio, you're in no better position than OIC.
We were, even with a lower portfolio, we already were at a better position than OIC in the volume rebate schedule. We were around 2%. Whereas they were at sometimes 0.5%, 1%. The maximum that they have had, which I reviewed when they disclosed the document, they reached, I think, 1.5%. Whereas in our contractual, we were at 2%.
You say that the general rule was that rebates were linked to the number of patients, the number of lives.
Rebates, usually, they are linked to the amount of claims in a specific provider.
The correlation could be very broad, couldn't it, between rebates and...
No, it's a direct correlation.
Could we just look at the period of pre-joint venture GMGHS losses, which I think is you've set in a table at D346. So in 2011, there were 24,000 lives, and the rebates rate is 2.63%.
Yes.
And then the number of lives almost halves to 13,000 lives, and yet the rate of rebate drops a little, but not as much. Yes,
but if you see the amount of claims is not the difference in the amount of claims between 2011 and 2012 is not as much as the difference between the number of insured lives. So the lives in 2011 to 2012 dropped from 24,000 to 13,000, whereas the amount of claims in 2011 were at 63 million, and it only dropped to around 51.7 million. And this is normal in a TPA business because the claims does not come immediately at year end. For claims, there are no cut-off. So the claims of a previous year, they will continue to drag at least 3 to 4 months after the closing of the year. And these figures in the number of lives, these are the figures of lives at the end of the year. So this does not mean that all the year during 2012 we were at 13,000. We definitely had started the year at 24,000 because the closing of 2011 was 24,000, and it went down to 13,000 to reach at the end of the year. So it's a gradual decrease. It's not an abrupt decrease.
You make a valid point about focusing on value of claims. So if we look at that column now, you look at the difference between 2012, 51 million claims, and compare that with 2014, 9 million claims. So a very substantial fall in the number of claims.
Yes.
And yet, the rate of rebate only halves, doesn't it? So a much smaller proportionate fall in the rate of rebate.
The same explanation, because when we say that at the end of 2014 we are at 1,800, this does mean that we started the year at 5,000, and we decreased over the year. So the figures make sense, and these are based on actual data. These are not assumption. This table was based on actual data.
And if you're an insurer with a very small number of lives, you'll obtain a low volume of rebate, but the rate of rebate may still be relatively high. If one looks, for example, at 2014, you've only got 1,800 lives, and yet the rate of rebate is still 1.18%. So it's almost 1% of rebate for 1,000 lives.
Yeah, but 1,000 lives, but 9 million in terms of claims. And the volume rebate amount is linked to the number of claims.
Could we just look at, well, before we do that, the converse of that is that if you're a very large insurer with hundreds of thousands of lives, you'll get a very high volume of rebates, but the rate of rebate may be relatively low. So if we look at paragraph 101, which I think is over page. And if we look, for example, at 2017, the number of lives is 481,000 odd, and the rate of rebate is 1.61%. So for 1% of rebate, you have 300,000 lives in that case.
This is the controversy talking about, and this is why we said that we had definitely to take the best of the two contracts between the providers and the TPA or OIC. OIC had definitely better tariffs than the TPA. The TPA, they had better volume rebates, and our intention and our plans were to take the tariffs of OIC and negotiate better volume rebates with the provider. Actually, during our negotiations and our financial modeling before the signature of the MOU, and when we approached this volume rebate issue, the network manager of IC at that time, I recall very well, he told us that we never focused a lot on volume rebates. We always focused on tariffs because we are the only, one insurer, two providers. So they always focus on tariffs, but they never focused on volume rebates. So he admitted this. And this is part of the strategic partner model, whereas you have one insurer giving you a high number of claims, reaching high volume rebates, and then all other will join to benefit from this. And it will get this synergy. Each and everyone will benefit from the claims of each other.
So your evidence is that OIC's eye was off the ball when it came to volume rebates.
Excuse me, I didn't understand this expression.
Some further evidence of a conversation with someone on the OIC side, and you sought to suggest that they hadn't really focused on volume rebates. Their attention had been focused on tariff rates.
This is what they said to us.
Which isn't something you troubled to record in your witness statement.
Maybe I didn't find relevant to mention this at that time.
What you do say in your witness statement is that had you taken an aggressive approach to negotiating, you could have improved the rebate terms.
Yes.
As a matter of aggression in negotiation.
Yes.
Could we just go back to the table at paragraph 99? Now, as I understand it, you became the CFO in 2013, having joined from Sodexo.
Yes.
And you presumably would have had figures very like these in front of you as the CFO in Beirut.
Yes.
And you would have seen that the UAE business, if I can call it that, was failing.
Yes.
And you would have been told that there was going to be a new level or layer of regulatory cost in bringing the relevant company onshore.
Yes.
And a decision was then taken, I assume, to make new approaches to insurers. Is that the decision?
New approach?
Or to approach some new insurers. Swiss Re hadn't worked out. That had...
I wasn't there when Swiss Re left, but if I remember well, it was around 2000. I don't know when they left, but I was there when the decision was taken due to regulatory change was taken to have an onshore company. Yes.
And an approach was made in 2014 to OIC. Were approaches made to other UAE insurers?
I wasn't involved in the business development in Dubai. Same as I'm not involved in our operation, because our model in all the countries where we operate, we have independent entities, and my role as a CFO of the group or vice president finance of the group is to supervise the financial activity and the financial performance of these entities. And also I am part of the internal audit committees. Sometimes I share some of that. So I'm not involved in their daily operational or daily business development lives. But as part of the report, the quarterly management report that I receive from our operation, yes, I know very well that they what are their operational performance and their business development plans.
And both their performance and their plans would have been pretty desperate at this point in time, wouldn't they?
Desperate, I cannot say desperate, but they were making a lot of business approach to practically a wide range of clients.
Were any other insurers interested?
There was some contract signed with some clients, but once again, the business in Dubai didn't pick up because GlobeMed model always insisted on the exclusivity between the insurance company and the TPA for the benefit of the insurance company, because we believe that when the insurance company will go and shop around for all TPAs, we will lose the momentum and we will lose the efficiency. This is why GlobeMed model always insisted on exclusivity, whereas the business in Dubai didn't suit this strategy.
They would owe you exclusivity obligations, but you didn't owe the insurers exclusivity obligations, did you?
Yes, the insurance is supposed to give its business to the TPA on exclusivity, whereas the TPA has the right to serve more than one insurance to the benefit of all its clients, because we believe that by accumulating businesses from different clients, we will be increasing the revenues and reducing the share of fixed cost and applying the economy of scale and benefiting all our clients from higher volume rebates and better tariffs with the providers.
And in this situation of desperation, you would have been willing to take risks in order to contract with new insurers, wouldn't you?
It wasn't a desperation, but as a risk, as a TPA, we're not a risk taker. So the TPA is not a risk taker. The TPA is a service company. We manage the medical claims portfolio of an insurance company. We're not a risk taker. So it's part of our policy and strategy.
The BUPA clause was just such a risk, wasn't it?
No, it wasn't.
We look back at the table, paragraph 99. Now, it said that the table has been prepared. By whom was it prepared?
The table, yeah. By whom?
Yes.
By the local finance team of GLOBEMED Gulf. Each entity of GLOBEMED has its local management. They have the local HR team, the local finance team, so they are independent companies. They have their own board. Our intervention as a group with these entities and subsidiaries is at two levels. At one level, we are in most of the cases we are investor in these companies. We are shareholders, so we have the role of a shareholder. In some instances, we are not shareholders. For example, we have GLOBEMED Palestine, where we are not a shareholder. In other, GLOBEMED Lebanon also as a group is not a shareholder. But in other instances, in most of the cases, GLOBEMED is a shareholder in its subsidiaries. This is one from one side. From the other side, GLOBEMED group is the provider of the know-how. We provide them all the guidelines, all the know-how to perform their business, and we provide with them the hosting capabilities for their services, for their IT systems, and we provide the IT system, the claims management, the GLOBEMED, what we call the GLOBEMED claims management system to perform their business.
You've been asked only about this table, this one.
My question to you was,
so this one was prepared by the local finance team of GLOBEMED Gulf Healthcare Solution, same as all the report that I receive.
And when it says has been prepared, that presumably means has recently been prepared by the GLOBEMED
yes.
finance team.
Yes. Supposedly at my request, when I wanted to review during the preparation of this witness statement, and I had to review the performance and compare what GLOBEMED GMGHS was performing at the level of volume rebates compared to what OIC gave us in terms of numbers of volume rebates.
What's striking to this table is the absence of any information as to the mix of lives or insurers. It's almost impossible to compare with the table over the page, isn't it? Because we know almost nothing.
This table, the intention of this table was to show the amount of volume rebates and the percentage of volume rebates. So in this table, I didn't find any relevance to ask from the local team to send me these volume rebates in terms of different categories of people. But if I recall best, at that time, all the GLOBEMED Gulf portfolio was based on private business. There was no basic lives at that time in GMGHS.
The suggestion you seek to make is that GMGH, as shown in this table, could make rebates of around 2.5%, whereas over page, if one looks at OIC,
it's 2.6, the maximum.
Okay, 2.6 maximum.
Yes.
Over page, the suggestion is that OIC were less good at negotiating rebates because they, in 2015 to 2019, were only achieving rebates of around 1.6%.
This is based on data that was provided by OIC.
But to validate that comparison, you really need to know quite a lot about the mix of lives and insurers in the GM-GHS data, don't you?
No, I need only to know what is the number of claims. There is no correlation here in determining the volume rebates and the percentage of volume rebates. There is no correlation between if this claim generated by a high premium or a lower premium. The claim is a claim for the provider.
You say in paragraph 103 of your statement, you consider that GM-GHS would have negotiated rebates of 2 to 3%. That is pure speculation on your part, isn't it?
If I'm already at 2.6, I can say easily that I can reach 3%, and the 3% is still conservative. We could have reached more if we were to service this large number of portfolio.
But the 2.6 is based on a tiny sample of GM-GHS offshore companies failing portfolio in 2009 to 2014. That's a mile away from looking at OIC with its hundreds of thousands of lives some years later.
A sample, but it's a relevant sample. We had a certain amount of claims. These claims generated this amount of volume rebates. It doesn't matter if the 24,000 were being there for 5 years, 6 years, or even 1 year. The 24,000 members was there in a specific period of time. They generated a certain amount of claims, which led to this volume rebates. It's relevant and it's representative.
I mean, apart from the disparity in the size of the relevant portfolio, I mean, it's a different period of time, isn't it?
What do you mean?
The GM-GHS figures are 2009 and the following 5 years. The OIC figures are 2015 to 2019. The market changes, doesn't it, Mr. Saliba?
The insurance market always, it is in a complete change. It's in a complete evolution. But if we are discussing here, still discussing the volume rebates point, the volume rebate doesn't change a lot. The volume rebate with time, they improve. They don't go back, because even if the market changes, the relationship between the provider and the TPA or the insurance companies will not deteriorate. On the contrary, it improves.
The rate of volume rebate generally improves as a market trend over time. Is that a fair summary of what you've just said?
The volume rebates generally, with time, the TPA can improve its position in volume rebates. The volume rebates are sensitive to the number of claims. They are not sensitive to any other market trends.
Lastly, on volume rebates, as to distribution, you'll recall there's a system of slabs, wasn't there, in the TPA agreement?
Yes.
And as to the first 16 million dirham, all of that rebate would have been kept by OIC, wouldn't it?
The 16 million, there was an error in the MOU. Actually, it was 15 million. It was a typo error, and I think that this typo error was clarified in one of the documents. So the first slab was 15 million, yes. Because when we were negotiating with OIC the fees and the distribution of volume rebates, when OIC imposed on the TPA the 33 million fee, and this 33 million was that it was their actual cost, their internal cost, and they cannot afford to outsource this business to a TPA and pay more from what they were paying. So this is where the 33 million came. And when we told them that the TPA usually share the volume rebates between the TPA and the insurance company, because the TPA has a role in collecting these volume rebates and in reaching higher volume rebates. So they told us, currently we are getting 15 million. So we cannot accept to share with the TPA the 15 million because we already has this 15 million. This is why we accepted to put that the first slab of 15 million will be reserved for OIC. From the second hand, we told them, so if we can bring any other amount above the 15 million, we will reserve for the TPA a 5 million slab as a reserve, and then any amount beyond the 20 million will be split 70%, 30% between the TPA and the insurance company, same as we do in most of our territories.
Two things. Firstly, are you suggesting this is another error in the TPA, another typographical error? We've looked at Article 12.
The 16 million is a typo error. The first slab was supposed to be 15 million. The second slab, 5 million. But if you do the math between the 15 and the slabs, it will be 16. This was the typo error, and this typo error was clarified. But I don't.
And the consequence of that first slab would be that the proportion received by GMGHS would have been less than 30%, wouldn't it?
I didn't do the math, but OIC was supposed to receive the first slab of 15 million. If just in case GMGHS would have been capable to bring any amount beyond the 15 million, it would have taken the second slab of 5 million. If you do the percentage of 5 million out of the 20 million, it represents 5 out of 20. It represents 25%. So it's somehow. This is why actually from where the 5 million came. It recouped the 30%.
To the extent that you are discounting off the industry standard rate, 30%, that reflects just how keen or even desperate GMGHS was to obtain this contract, this TPA agreement.
Once again, I don't like to use the term desperate, but what did we discount? We didn't discount. We respected the fact that an insurance company being internally serviced, getting a certain amount of volume rebate, and we were here coming as a TPA to provide them the service that we, as a when we did the proof of concept, it showed to this TPA that we will be giving for them more savings on their claims, because when they did, before signing the contract, they did a proof of concept. They gave us a sample of their claims, and we ran these claims on our system, and it showed that we were capable to provide 17% savings. This resulted in an addition of 12.5 savings from where they were doing the saving. But at the same time, they told us currently we are having a revenue in terms of volume rebate 15 million that we are not ready to give up. So we respected this will. And on the second side, we requested a reserve slab of 5 million, which represent, if we take the 5 million out of the 20 and the 15 million, it is more or less the same between the 70-30 distribution.
I'm going to move on to personnel costs. Could we look at F23615? This is a table of personnel GMGHS in May 2015. Was this produced at the time? Is it a contemporaneous document?
This was produced for this study, taken out of the payroll sheets of 2015.
At the time?
Yes.
And by whom was it produced?
Usually the payroll sheets are prepared by the HR management and approved by the finance for the payment of the payroll.
But finance at a much lower level than you, presumably.
It's not a matter of lower level or higher level. It's a matter of the finance team of the operation, which they report to their general management and they report to their board. My relationship or the group relationship with the operation it's not a line reporting, it's a dotted line reporting.
You in Beirut were not going through?
No. No, they prepare their payroll, they have the authority, they have their authority matrix, they have their signatories. Each operation, they have their separate book of accounts, their local signatory authorities between finance people, non-finance people. So they are independent. We manage by reporting. We receive reports from them, we challenge their budget, we have quarterly reports, we review these. My team in Beirut, I have financial analysis, they review all these reports, but we don't intervene in their daily activity.
Financial analysts go through this data as it comes in from the relevant subsidiaries.
Yes.
Now, the table helpfully identifies various categories and various departments and teams, but the ranking or the allocation is pretty crude, isn't it? You're either junior or you're management. It doesn't break down into very specific salary bands, for example, does it?
It's management. It doesn't state that it's higher or lower management. When the intention of this categorization was to identify the variable cost from the fixed cost in terms of HR staffing.
And we see that there is somewhere between 1 and 4 managers for each team.
No, you cannot. You cannot take this straightforward formula. Usually the management in a TPA business, you have the first line manager, the second line manager. These people are fixed, and whenever you enroll more and more members, or you enroll more and more clients, you have to increase your junior capabilities. So if a TPA has a large number of people, a large number of members servicing, or large number of clients, it will become much more performing. But the finance manager will be always a finance manager for the whole TPA, same for the HR, same for the general manager. Some first line management are combined when the TPA is in its early stages, because it cannot afford all these fixed costs.
Could we go to page D350, paragraph 111? You say there, in my view, so you're giving an opinion, there would be one customer-facing member of staff for 6,750 lives and one support staff every 15,000 lives. Those are very precise estimates, aren't they?
It's my view, and based on my experience, yes.
Your experience as CFO?
Yes.
Those estimates come from someone else, don't they?
It comes from the local teams, definitely.
And those, as to the staff requirements, are not reflected in any existing policy documents or professional literature?
No, it's not a policy. It's the result of the analysis of our data performance and HR plans that we receive and financial reports.
Your financial analysts will measure team.
It's not my financial analyst. Usually this is done at the level of the operation. So when we want to bid for new large projects, or when we want to review the forecasts of any changes in the market, so usually we use this type of KPIs to do our projections.
So these are internal KPIs?
Yes, these are internal. It's not an external rule of thumb.
Can we look at F1 1497, moving on to general operating expenses?
Yes.
This is a table, isn't it? It's a matter of pure estimation, isn't it?
Yes.
Indeed, it's not even your estimate, it's that of the GMGHS finance team.
Same as all financial report that I receive, and same as all forecasts that that are being prepared at the level of the operation and sent to the group for review.
This was produced for the purposes of this litigation, wasn't it?
This was produced in retrospect when we wanted to review what was done in 2015 in the MOU, and 2-3 years later, when we started this litigation, we wanted to validate what was done, and we came up with these projections. They don't differ much from the figures in the MOU. There were some adjustments on the other hand.
You came up with these projections, or rather your finance team came up with these projections.
What do you mean if I came up?
We came up. I just wanted to make clear whether it's
personally, no. Personally, usually we manage around 12 operations. We manage around 23 million members between private business and public business. We have billions of claims in terms of medical claims. So I cannot, as a VP Finance of the group, I cannot make all this report for each and every operation. I have to rely on the reports that I receive from the local operation.
Quickly on the ramp down period, you say it's reasonable to assume that lives would migrate back to OIC over a year. That's a matter of opinion, isn't it?
No, this is a matter of fact, because usually the ramp down or giving back to an insurance company its portfolio, it's preferably to be done on a runoff basis. So on renewal, DTPA will transfer the portfolio, the specific group, because the business of an insurance company comes on monthly renewals, so it's not one bulk. So usually the insurance company, they prefer to get back their portfolio on a runoff basis. So on each renewal, they will say, we will renew this group at our levels. This is why we call it a runoff giving back portfolio.
And you say the reduction in staff cost would, in your assessment, track the reduction in lives?
Yes, because we have the renewal calendar of the insurance company, because we are managing their portfolio. So based on the renewal calendar, we know exactly on each month how much there will be a reduction in the terms of numbers being serviced by the TPA, and we can know ahead of time how many members we will have to get to terminate, how many employees we will have to terminate, and we can give them early termination notice so they know for themselves to look for new work, and we will not be subject to pay for them penalties, termination penalties. It's a calendar. You plug everything in this calendar and you follow the project.
The reality is there's a significant lag, and the reason there's a significant lag is that you have regulatory obligations. You have to cover, for example, with your support and claims teams. You can't simply track the decline in lives with the number of employees. You have to be left, for example, with your support and claims team.
Yes, yes. This is when we do the ramp down project, all these factors are taken into consideration. For example, when we start the ramping down, the highly sensitive type of employees who are directly linked to the existence of these members being serviced by the TPA are the PSD, the Patient Service Department. These who give the pre-authorization, or they answer the calls whenever there is a member who has any concern about his approval. So usually whenever there is a reduction in terms of numbers, immediately the number of the patient service department are immediately reduced. Whereas the persons that are in the claims department, they are reduced after several times, because always there is a lag between the departure of the members and the receipt of the claims. We have to receive the claims within 2 or 3 months after the fact, and we have also to perform the reconciliation with the provider. This is why the lag time between the departure of the members and the reduction in certain type of employees, mainly in the claims department, are within 6 months.
If we turn to page 323. Sorry, D323.
Which one?
D323.
Okay.
This is information obtained from GLOBEMED Kuwait. Now, I understand the source of that is the document at F1 1489. We just confirmed, is that a table prepared for the purposes of this litigation?
Yes. Usually we don't go through this analysis, but for the purpose to give a direct impact of the strategic partner, I asked to get this table prepared, and this comparative and this evolution.
Sleeva, I can't help but notice that your approach to giving answers on Friday was very different to your approach today. On Friday, you gave short, concise answers. Today, you've been giving much more expansive answers to questions. Has anyone spoken to you about your evidence?
No.
The reality, Mr. Sieber, is that the first half of your statement, selective quotation from emails to which you were not a party, the second half of your statement provides estimates and assumptions as to likely revenue and costs. It's therefore a matter of opinion of you and others in GLOBEMED, opinion that's far from being independent.
No. This is based on this is based on GLOBEMED experience, 30 years of experience in TPA business. I cannot accept to say that this is an opinion.
An opinion can be based on experience, but it remains an opinion.
Cannot tell.
I have no further questions.
No re-examination from me, Your Excellency. Thank you. You
Can dismiss?
Yes, unless you've got any questions for
Thank you,
witness. Thank you.
Thank you, Mr.
Thank you.
Secretary.
Thank you, Your Excellency. Thank you.
For the next one.
The next witness is one of the friends.
Yes, the defendant is now going to call his evidence, its evidence.
Yes.
But it is now a good time to have a break for the transcriber. I'm in your Lordship's hands.
Usually we should break at 11:30, but you think it's better? I'm flexible.
I think it would be better to break before we start this.
Sure. I have no idea. Yeah. So,
In your hands.
all right, so we'll break for 10 minutes and come back, let's say 11:15. All right, thank you. All right. Okay.
Your Excellency, the defendant calls Mr. Anwar Al-Khatib.
Yeah.
My name is Anwar Al-Khatib. I will be swearing. Swear by the Almighty God to say the truth, the whole truth, and nothing but the truth.
Could the witness be shown page D354? Have it. Is this your witness statement given on the 10th of June 2022?
Yes, it is.
And could you turn on, please, to page 389?
That's my signature.
Grateful. Statement was given some time ago. Have you had the chance to reread it?
Yes, I have.
And can you confirm the truth of its contents?
I can confirm that.
Stay there, my learned friend will have some questions for you. Apologize. Could you turn on to page 405?
Yes?
Is that your second statement given on the 22nd of July 2022?
Yes, it is.
And can you turn on to page 424?
That's my signature.
And have you had the opportunity to reread this second statement?
I have.
And can you again confirm the truth of the contents of this statement?
Yes, I can. Okay. It's confirmed.
Good morning, Mr. Al-Khatib.
Good morning.
My name is Mr. Montague-Smith. I'll be asking you some questions this morning and possibly into the afternoon, but let's see how we go. Now, you've been in court throughout these proceedings. Yes.
But on the other side.
Yes, of course. And I want to ask you about the negotiation and agreement of the TPA services agreement. And just so I can understand your role in that, it's right, isn't it? You were not directly involved in the negotiation of that contract, were you?
I was directly involved in the legal and contractual side, not the commercial.
So you did not engage in. Thank you. Sorry, am I being picked up all right? Sorry, we had a problem. I wasn't speaking closely enough to the transcriber's microphone. So you were not directly involved in the commercial negotiations, is the agreement. And if we look at your statement at page 361, please. If we go to paragraph 21, set out in paragraph 21 the key team of executives who are involved in the transaction, and there's a number of them, and then there's another set of individuals identified at paragraph 22. But of these individuals, you identify at 21A Mr. Shofel, and at 21C Ms. Hajar Fadel. And I think in relation to Ms. Fadel, you describe her as being effectively the project manager of this transaction.
To an extent, yes.
So would it be fair to say that she would have had a general overview of the whole of the project?
Yes.
And would it be fair to say that she was closer to the negotiation of this?
Yes, she was.
And when it came to the days after the January meeting, she was also closer, wasn't she, to the operational aspects of the transition?
Yes, she was.
So when, I think in your statement at paragraph 8, we go back to page 356, you say, paragraph 8, I'm giving this witness statement because I am the member of OIC's team who likely had the best oversight, overall oversight of matters. What you really mean there is you are now, of the people who has left at OIC, the person who has the best overall insight.
Sorry, I didn't get the question.
So what you really mean when you say, I am the person with the best oversight, is you are now the person left at OIC who has the best oversight. Whereas these other people that you've identified, some of those would have had a better oversight of the negotiations and the implementation.
Probably.
Now, all of those people that you have identified at paragraph 21, we can look at it again, it's page 361. All of those people have now left OIC, is that right? Yes. And you don't say in your statement that you have spoken to any of them since they left the company. So do we take it from that you have not?
I've met once of a coincidence with Mr. Shofel.
I see. But you didn't discuss with him the issues arising in this case?
Not at all.
And your answers are very short and excellent. If you could, though, just for the transcriber's benefit, wait until I've finished asking the question and then answer. It's not meant as a criticism at all.
Absolutely.
It's an unusual experience. All right. So, for example, Ms. Fadel she left the company in 2016, and you've had no contact with her since 2016, then?
Correct.
And I think Mr. Schoffel left the company in 2015, and you haven't discussed the issues arising in this case with him since then.
That is correct.
And if we look down this list here, I think two left in 2017, one left in 2019. In relation to others, you don't say when they left. Presumably you don't know when they left. Is that why you left that out?
Exactly.
And presumably you had to ask somebody else to get the information to decide to find out when they left. It's not something you would have known for yourself.
I would know that Mr. Andrew Brody left in 2019 because he was still there after all this
I see.
action.
But when you made this statement in June last year, is that right?
Yes, correct.
And so when you made that statement, you were relying on, when we're dealing with the issues you weren't terribly closely involved in, like the commercial negotiations and like the implementation of the project, you were relying, presumably, on documents that you had read and conversations that you had had with people in the past about what had been going on.
Yes.
And in relation to those conversations, when you made this statement in June last year, you would have therefore been relying on your memory of those conversations from 5 years before, or more.
Whenever I remember things, yes.
So would you say that, in the main, when you're dealing with those sorts of aspects of this dispute, the best guide for you has been the documents?
Yes, correct.
Now, I'm going to ask you about the meeting that took place in January 2015, which is the meeting at which, to put it neutrally, these two documents were signed. Now, I think you've accepted this. You weren't directly involved in the negotiations prior to that meeting, is that right?
Correct.
And Ms. Fadel was the main OIC contact, was she, along with perhaps Mr. Schoffel, Patrick Schoffel?
And Mr. Taldena.
And Mr. Sorry, I didn't catch that.
Mr. Taldena, the CFO back then.
Yes, of course. Now, it looks like before the January meeting there were a number of in-person meetings and video calls which took place at which the contract was negotiated. You weren't at any of those meetings or on any of those calls, were you?
Whenever there were meetings related to the some contractual terms and conditions and related to legal matters, I was involved.
Well, when were those meetings that you, prior to January 2015?
I think I will have to go through my witness statement to remember that. I think maybe in December, if I'm not mistaken.
So my understanding of your role was that you were brought in to deal with the due diligence side of things.
Yes.
But that took place in late October 2015?
Yes.
So, for example, by the 15th of October 2014, you would not have had much involvement in the contractual negotiations?
No, not really.
And can I ask, if we can go, please, to Bundle F, page 1835. We can see there, this is in the middle of the page, an email dated the 15th of October 2014. Do you see that? It's from Ms. Fadel to Mr. Munir, and various different people are copied on this, but you are not.
Yes.
And what this says is, Dear Munir, thank you for your email, and we are hopeful to close this deal to the satisfaction of both sides. We can discuss the key principles of the TPA service agreement in parallel with the MOU. However, please understand that our assessment will be complete once we conduct the due diligence, including exchange of information, on-site review of GlobeMed's processes. As you are aware, the due diligence will kick off this Thursday with legal and compliance and continue next week when Roger S. is in Dubai. And then they provide comments on the TPA services agreement. So by 15th of October 2015, before you became involved in this, we can see the parties are already talking about closing the deal, yes? And by closing the deal, you would understand from that to mean signing a contract.
Yes, subject to the due diligence.
Subject to the due diligence. And that due diligence was going to start in the following week. We can see that from the email.
Yes, this is what I see.
And that was going to be part of the final assessment of the transaction.
I believe so.
And then I think I said late October, but in fact, if we go to page 1845, please. Looks like this is when you are brought in. In the middle of the page, you see from Ms. Fadel to you, she says all, the due diligence of GlobeMed is progressing at a, I can't read that, I'm afraid. Fast, thank you, fast pace. And we need to mobilize a team for this exercise. To start with, we would require staff from your respective department to review their areas. See attachment. The due diligence will start on Wednesday, October the 15th. So that really is when you were brought into the discussions. Is that right?
Yes. Now, I think also I was asked, I don't remember the date, but there was the non-disclosure agreement that was being exchanged. So I'm not sure.
Yes.
Just to make sure that we are on the right track.
I think that's absolutely right. You were asked to provide a non-disclosure agreement right at the outset in about August, would you say?
I believe so. As I need to go through if you have the...
It doesn't matter for my purposes, because I think what I'm suggesting is that between those two dates, you weren't really involved in the project.
No, I was not.
During the course of October, there is further negotiation of the contracts which you are not involved in. Is that right?
I don't remember any, yeah.
Now, in relation to the due diligence, there's a relatively minor issue between you and Ms. Atala, and I think you were here and heard her evidence. You sat through Ms. Atala's evidence, did you?
Sorry, I didn't get that.
Did you sit in court while Ms. Atala was giving evidence?
No.
You didn't? You didn't hear what she had to say?
No, I was not.
See. All right, well, let me explain the issue. In the course of the due diligence, you reviewed, didn't you, the side agreement by which the shares were held in GlobeMed, the claimant?
Yes, I have.
And I think what you say in your evidence is that you raised concerns with Ms. Atala about it.
No, what I said is I had asked about the structure, about the side agreement, but the concerns were raised internally within my team, within my management.
I see. So I think the way it was put to Ms. Atala was that you directly raised concerns with her, and she was adamant that that hadn't happened. So you would agree with her that there were no discussions between you about it?
I honestly don't remember that I have.
Now, if we move forward in time a little bit, but by the time we get to the end of November, is it fair to say that the terms of both the TPA agreement and the MOU agreement were really reaching finalization?
There was, as I remember, there was a lot of back and forth, and there were some points that I think were still pending, and this is why we decided to go to Beirut, if I'm not mistaken.
To resolve the issues that were outstanding?
To have like everything finalized, yes.
So if we just take it in stages, if we go to page 1911, please. You can see Ms. Fadel at the bottom. Do you see there on the 30th of November? she's emailing Abhishek Kishore. Abhishek Kishore was effectively your number 2, is that right?
Yes.
And so she's asking Mr. Kishore, Abhishek, please send me the final version of the GM TPA following modifications. And then the response comes back above on the same day. I don't think we need to read all of it, but if you look at the 3rd paragraph, as many points were common in between the TPA and MOU, hence Patricia should be sending both versions together for final review. So it's pretty close at this stage, end of November, to the final document. There's a few outstanding issues, and you're going to talk about them in Beirut.
Yes, this is how I remember.
And in the course of that discussion, before they got there, you may not know anything about this, but is it fair to say that the parties in December of 2014 finalised agreement on the pricing structure for the TPA services agreement? Would you accept that?
I can't really tell, no.
I see. So if we look at the documents on that, we can be guided by those. Thank you. But well, you do actually give some evidence on this, so I'm just going to show you one document, if I may. If we look at page 1977, see there is an email from Mr. Saliba to Ms. Fidel, and various others, including Mr. Shuffle and Mr. Taldana. It says, Dear Hajar, and then the 2nd paragraph down, in reference to the below, and since we agreed on the financial terms, can you please advise when do you expect to send us your final comments on the MOUs as previously discussed with Patrick? So it looks, doesn't it, like they had agreed finally on the financial terms for the TPA.
This is what he says, yes.
I see. So you doubt that, do you? You're not sure? You don't accept that?
Based on the discussions that happened in Beirut, yeah, now I doubt, yeah.
Doubt it. All right, we can look at it then. So if we go to page 1980, see there you've got at the bottom of the page, Mr. Eli Tomi on the 13th of December. Now, Mr. Eli Tomi was on the GLOBEMED side, and he says, Dear PJ, that's to Mr. Taldana, who's the CFO of OIC, please find attached the new pricing model suggestions. So he's proposing the pricing model, and then there's discussion, and if we go up to page, please, 1979. We can see that there's an email there. You are then copied in on this, aren't you, on these discussions? You see the email at the bottom.
Yeah.
And then on the following page, you have negotiation. So they're talking about the average fee. They're talking about the bands, the maximum bands for the TPA administrations at 33 million. There's the profit sharing provisions and various other aspects. And then if you see in page 1978, see that, Dear PJ, from Roger Saliba, in response to this counter-proposal, further to your comments below and based on Ellie's below clarification, we propose an alternative to the previous pricing model, whereby we split the first bracket into two sub-brackets and so on. Then the discussion continues. Above, you've got Mr. Taldana coming back and saying a small point on that, and then Ms. Fidel says, Hi Roger, this is on page 1977. In addition to PJ's email below, kindly note that OIC has a larger network, copying Mr. Choffeld to confirm that our position vis-à-vis your network remains unchanged, and then you get the email above from Mr. Saliba. In reference to the below, and since we agreed on the financial terms, please can you advise? And then you get the response back from Ms. Fidel, which is on page 1976. Please find attached our comments on the MOU and TPA agreement for your review. Kindly advise on our management's availability early January to resolve these face-to-face. So it looks like there was some measure of agreement, doesn't it, as to the fee structure before the parties went into the meeting in January?
This is how it looks like, but I cannot decide, although I was copied, but I wasn't really involved, so I couldn't really understand to what extent those were accurate.
I see, because, I mean, in your evidence, go to page 375, please. Paragraph 61. You say, from the documents I've seen and as I believe to be true, parties engaged in discussions regarding GLOBEMED's remuneration and fee structure under the draft TPA agreement, the majority of which took place after the TPA agreement and the MOU had been signed. So it looks like that's wrong, isn't it? It looks like the majority of the discussions took place before the TPA agreement was signed. Would you accept that?
Looks like it, but I was not involved in these discussions.
I understand that, but you give evidence here saying things that have happened. I think what you're saying to me now is that evidence will give way to the documents, and we should really look at the documents because you don't really know. Is that right?
This is what I said at the beginning. The commercial terms I was never really involved in. I was copied, and I'm saying here that based on what I've seen in the communication, it looks like.
And so when you say you were never really involved in relation to that aspect of things, you weren't involved before, during, or after the January 2015 meeting?
Yeah, to the extent even that when we were in Beirut, when they were discussing figures, I wasn't really understanding what is happening.
All right. Now, would you say that internally within OIC, in the lead up to the January meeting, everybody within OIC was clear that the draft that was being circulated at that stage was virtually the final document?
I believe so to a certain extent.
Well, can we go please to page 1982 then? See, there's an email from Ms. Fadel.
Yes.
And it is copied, amongst others, to you. And what it's doing is it's saying, please find attached the latest versions of the MOU and TPA agreement, which incorporate feedback received as per the below table. And then do you see towards the end, the last full paragraph? Please note that you are all requested to review the amended agreements attached by December 16th. No changes will be accommodated past this deadline. So what Ms. Fadel is saying there, isn't it, is we need to gather in all internal feedback so that we can know and go into this discussion knowing where we stand and being able to conclude a contract.
Maybe this is what she meant.
Is that how you understood it at the time?
Yeah, more or less.
So you knew before you went to that meeting that the drafts that you were looking at of these two documents, they weren't some sort of progress report on negotiations. They were intended to be, as closely as possible, the final versions that would be made into contracts.
Yes, I believe so.
Now, can we agree on this, that at least up to this point, there has been no mention in the negotiations of any preconditions being inserted about licensing or about share transfers up to this point?
Because I was relying on the reps and warranties clause.
I see. All right. So, but just on the factual question, there had been no discussion up to this point of any of these preconditions that you said.
I don't remember.
You don't remember?
I don't remember this discussion.
You've been through the documents, as I understand.
Yes, I have.
And you would have seen those discussions in the documents if they were in the documents, wouldn't you?
In the documents, no, I haven't raised this, or I haven't seen that.
And very good. And can I put it like this? If there were these important preconditions that were under discussion, you would likely have seen them in the documents, wouldn't you? It would have made it into at least one email over the many months of negotiations.
As I said before, I relied on the reps and warranties.
I see. So you're not saying that there were any express discussions at all between the parties to say, we agree that this is conditional on X or Y. You're just relying on the reps and warranties.
Yes.
Right. So after this sort of deadline for internal discussion, the January meeting is then set, isn't it? Now, you didn't fix the meeting yourself, did you?
No, I haven't.
But was it fair to say that the purpose of the meeting was to sign off on the deal and to finalise the terms of the agreement? And the meeting took place, didn't it, over 2 days?
Yes, correct.
And is it fair to describe day one as being, well, really the negotiation of the final remaining outstanding points between the parties?
From the documents, this is what refreshed my memory, yes.
And as you said, I think you were very much in the background for that, and some of it you didn't really understand because it was commercial.
That's very correct, yes.
Now, at the end of the first day, you were then sent the draft of where everybody had got to. Is that right? I can show you if you can't recall.
Yeah, maybe it was sent.
It's a long time ago, I accept that. So if we go to page 2047, you see there at the bottom of the page, there's an email from Mr. Saliba, and he sends it to you and various other people. And it says, "Dear all, attached is the version that we worked on during our meeting of today." And then above that, you forward that on to Mr. I think Kishore, and then he comes back to you a little later. In fact, he comes back to you the next morning. So what he says is, "Hi, boss." So this is directed to you. "I've gone through the changes. I'm fine with them." And then he says, "Maybe you can request Hajar to chase up Dr. Yasser to provide his confirmation also before this is signed off, so that if he has any concerns on these, he should raise them now." So he is telling you, let's double check with Dr. Yasser, and he's the head of insurance, isn't he?
He was the head of medical insurance.
Medical insurance, thank you. And he's saying, if there are any objections to what we're proposing to agree, raise them now.
Yes.
And he was saying that because if they weren't raised now, it might be too late to raise them later.
Yes.
And it would be too late to raise them later because by then the parties would have been bound into a contract.
Yes.
Can I take you to page 377, please? Paragraph 69. Now, I'm just going to show you what you say in your statement, and then just ask you a few questions, if I may, about that. You say, you're talking about the meeting that we're discussing. In the second sentence, you say, "At the meeting, I remember the OIC team asking GLOBEMED staff to let OIC have internal discussions in private, where we discussed GLOBEMED and GML's insistence that Bupa's agreement would not be a condition preceding any agreement." So, in relation to Bupa, you're saying that there was a discussion about whether or not Bupa would be Bupa consenting would be a precondition to this agreement.
Sorry, can you repeat the question?
So I'm just reading from your statement, and I was saying, you are saying, are you, that you recall an actual discussion between the parties about whether or not Bupa would be a precondition to the agreement?
Yes.
And you say GLOBEMED were insisting that it should not be a precondition.
Yes, this is what I recall.
And you say, I was not comfortable, and I questioned Hajar Fadel during the same meeting, asking her about Bupa's agreement to the proposals when I had seen nothing in writing from them. The result of the Lebanon negotiations was the insertion of Clause 15 into the MOU. And then you say that clause was drafted and proposed by OIC. And then you go on to say it makes the MOU clearly subject to Bupa's written approval to allow the transfer of its reinsured portfolio within 1 month. And in the event that Bupa's agreement was not obtained within that time, the entire fee structure was to be renegotiated, at which time the fundamental basis of the transaction might have broken down. So you are saying that the result of that discussion about whether Bupa should be a precondition, or the whole result of that is that the parties agreed to insert Clause 15 into the MOU.
Yes, sir.
And so that discussion was entirely resolved by that agreement.
Yes, this is how I remember, yes.
And so the parties agreed that there would be no condition inserted into the TPA agreement so long as there was Clause 15 in the MOU.
Yeah, if you say so.
Well, I'm asking you for your view, your explanation of what happened.
Well, my explanation is, as I mentioned, for me, that was a very critical matter, and this is why I pushed to have it in. For the other conditions, if this is what is being implied, I took them for granted in the sense that it goes without saying that they need to be properly licensed in order to operate. That's my understanding for any operations.
I'm asking you about the Bupa issue itself.
Bupa, yes, that was the condition that made me comfortable to sign the MOU.
Your evidence on the rest is very clear. You said there was no express discussion, it just went without saying. In relation to Bupa, though, my point was this, that there was a discussion about whether the TPA agreement should be made subject to Bupa's consent. And that was resolved by the parties agreeing not to place any Bupa condition into the TPA agreement, but to put a Bupa condition into the MOU.
I don't recall having the discussion where this clause needs to be put, but I think I believe that I pushed to have it in the MOU, but I've always had the understanding that both agreements, they go together.
Well, I'll come back to that if I may, but just to clear this up. So your concern was that you were absolutely, it was absolutely essential that this Bupa clause went into the MOU, because otherwise you might be bound into a contract whereby you would have to, OIC would have to deliver even if Bupa did not agree.
Yes.
So you would accept then that if you take away Clause 15 from the MOU at least, you have here binding contracts.
Yes.
Now, I'll come back to the point that you made earlier in a moment, but can I just take you then to the TPA itself? Starts at page 2049. Have that.
Yes.
And you can see there, just on, this is the front page, you recognize it, do you?
Yes.
And you can see that it says in the middle of the page, TPA services agreement entered between the two parties on the 13th of January 2015. So the point that I'm making here is simply that the TPA services agreement was entered between the parties on the 13th of January 2015, wasn't it?
This is what it says.
And it means what it says. That was the intention.
I believe this is subjective.
It's subjective. You're a lawyer, aren't you?
Yes, I am.
Yeah. So, I mean, you recognize the importance of language in contracts.
Absolutely.
And so you would not have agreed to OIC signing off on a document that said it was entered between these two parties on that date if it wasn't what you intended to happen.
Because as a lawyer also, I base my assessment on intentions as well.
But not intentions that you expressed to the other side.
So the intentions was a good faith that this yes will be entered, subject to.
It doesn't say will be entered into in the future. It says it is entered between
Then if
on the 13th of January.
If we want to stick to the wording, then yes, you are correct.
But my point is that the reason for the wording is that it reflected your intention on the day, didn't it?
On the day, yes.
And then if we go forward, page 2051, please. See there at the top of the page, it says this agreement is entered into by and between, and then names the parties. So again, your intention on the day was that those parties should enter into an agreement, a contract. And if we go forward to page 2066, at the bottom of the page, clause 16.2.
Yes.
You would have read through all of this at the time because that was your job. Is that right?
Yes.
And clause 16.2 says binding effect. This agreement shall be enforceable and binding upon and inure to the benefit of the parties and their respective successors, transferors, and assigns, whether by merger, consolidation, partial sale or total sale, except the rights of this agreement hereunder shall not be assigned, transferred, or sublicensed in whole or in part without the prior written consent of the parties. So your intention on the OIC side was to enter into a contract that was binding.
Yes.
Bear with me. Sorry, excuse me, just for 1 second. That's very helpful. Yeah. So if we go to page 358, please. And can we look, please, at paragraph? So this is your witness statement, and it is paragraph 12 of your witness statement. There's a preamble on the previous page, and then you have 3 Roman numerals. And then I understood, and if we go to A, do you see in the middle of the page? You say first the agreement of Bupa.
Yes.
So you're saying that the document was conditional on the agreement of Bupa. You say, middle of the second line, the TPASA expressly recorded that the fee structure underlying the entire transaction was to be renegotiated. Now, we were looking at the TPA agreement, not the MOU, but the TPA agreement, if you take them separately. In fact, there's nothing in the TPA agreement that says that the fee structure is going to be renegotiated, is there?
For me, it's very simple. From day one, when I entered this transaction, for me, they went hand in hand. I can't until now separate them one from the other. So when I read one clause in one agreement, I also have the same interpretation for the other, or should apply or enforce within the other agreement.
I see. So you're not saying that there's some clause in the TPA agreement, the document, that says words to that effect?
I think the TPA refers to the MOU, if I'm not mistaken, or vice versa, if I'm not mistaken.
So maybe I can help you. If we go to the MOU, so that starts at page 2092. Recognize that document?
Yes.
And if you go down then to page 2103, you see there clause 15?
Yes.
Is that what you are referring to in your witness evidence, where you say the TPA expressly recorded that the fee structure underlying the entire transaction was to be renegotiated. Is that what you meant to refer to?
Yes.
So, looking at your evidence, what it really ought to say is the MOU expressly recorded that the fee structure underlying the entire transaction was to be renegotiated. Would you accept that?
Sorry, can you reask?
Your evidence, as I showed you a little while ago, said the TPA agreement expressly recorded that the fee structure underlying the entire transaction was to be renegotiated. You remember that sentence?
Yes.
Would it be more accurate to say the MOU expressly recorded that the structure underlying, etc.?
I'm sorry, again, I'm going to insist on what I said. I've always seen them as one transaction, that they are totally related to each other. So whether I said the MOU or the TPA, for me, it was the same thing for me. Both terms needs to be renegotiated.
So you recognize, though, that the MOU is a distinct contract from the TPA agreement, yes?
Yes and no.
Yes and no. Well, let's take it in stages. If we go back up to the top of the page, 2092.
May I explain what I mean by yes and no?
By all means.
I don't believe that we would have engaged with the TPA if we were not part of, if we were not as a shareholder of it.
Yes, so they're related. They have a common purpose or commonality of purpose. But you must.
The TPA would not have happened if we are not part of the company.
Yes, but one can say that about any number of different sets of arrangements and still recognize that they are two separate contracts. They're related, but they are distinct, yes?
I just explained my understanding, and this is what I will stick to.
I see. So you don't want to answer the question?
It's not that, but again, I'm trying to explain that I wouldn't be in this TPA agreement if I'm not a shareholder of the company.
But if we look at page 2092, the claimant entity is not a party to this agreement, is it?
No, it's not.
And you accept, do you, that the MOU, this document, was a binding legal document?
With the subject to BUPA approval.
Yes. So it's a binding legal agreement, but there's clause 15 in it. That's your point.
Okay.
But there is clause 15 in it.
Yes.
So clause 15 is a binding contractual term, for example.
It is.
So there would be an obligation on the parties to negotiate, for example.
Yes.
Now, one of the things that the MOU dealt with was the share transfer.
Yes.
And if we go to page 2093, we can see it. Clause 3B. Well, it's clause 3. So the partners agreed that the investment entity, that's Synergize, isn't it? Yes?
Yes.
Will acquire a total of 51% of GMGHS, that's the claimant. And then there is a set of terms about how that was to take place. And we can see clause 3B, the parties, do you see that, were obliged to undertake that share transfer. Do you see the third line, within a maximum period of 6 months?
Sorry to interrupt. Where are we reading?
We're reading from clause 3B.
B.
3B, B for beta.
B, the partners, okay.
Yeah. So the partners shall sign the necessary papers and perform the necessary actions to complete the sale of shares at the official authorities in UAE within a maximum period of 6 months as of the signature date of the present MOU. So the MOU was signed on the 13th of January 2015, yes? And so the parties were agreeing that the share transfer would happen by 6 months, within 6 months, so by the middle of July 2015, yes?
Yes.
Now, you're aware that I know you weren't involved directly in the operations, But you're aware that the parties were anticipating that services under the TPA agreement would go live in May 2015, yes?
Yes.
So it was anticipated between the parties that the share transfer would come after services went live, yes?
Yes. However, when we started the implementation or the attempt to implement the transaction, we were also accelerating the share transfer.
I understand that, but thinking forwards from the date you signed these documents, or not you personally, but OIC, if it was anticipated that the share transfer would come after services went live, it must also have been anticipated that the share transfer would come after the TPA service agreement was effective and binding.
Yes, the reason being we gave in somehow an extended period because we knew that there would be some logistic formalities with the government entities that may take some time. And this is why we gave ourselves a period of time just not to be rushed.
Yeah, very sensible. But my point is that if you're anticipating the share transfer is going to come after, then the share transfer can't have been a precondition of the services being provided, can it?
Again, I don't want to repeat myself, but again, I see it as one transaction. Now, the implementation did not mean that we will not be considered as shareholders. The actual transfer.
Yes. Well, let me rephrase the question then. If the actual share transfer was intended to take place after services commenced, then the actual transfer of shares could not have been a condition of the contract coming into effect and services being required. That's just logic.
As again, maybe we have exaggerated in having that long period to do the transfer, but again, the intention was to have the transfer very quick, along with the implementation of the TPA and the transition of lives and the whole operation.
Yeah, but clearly, I think I asked you a moment ago whether it was anticipated, or when it was anticipated that these things would happen, and you agreed with me that it was anticipated that the share transfer would happen in July, and that the services would start in May. So are you changing that evidence?
No, I'm not changing. I'm just trying to explain why we have had this 6-month period as a buffer, but the whole idea and all the communication after shows clearly that we were also rushing to have the transfer of shares, along with the integration of the operations.
Well, let me ask you about it this way. So this document imposed an obligation on the parties to effect that share transfer.
Yes.
And so the share transfer can't have had to have been have to have taken place before this document became binding, can it?
The share transfer would be in the implementation of this MOU.
Yes, so it wouldn't have been a precondition to this document becoming binding.
Okay, no.
So you also accept, I think, then, that this document was binding, regardless of whether or not the share transfer actually took place?
If you want just to limit it to the share transfer, then yes.
And would you accept the same, therefore, for the TPA services agreement?
Again, you're pushing me to repeat myself, but again, those were one transaction for me.
Well, given that you say they're one transaction, and I'm asking you about your intention at the time, you said that the actual taking place of the share transfer was not a condition of the memorandum of understanding becoming binding. They're one transaction. Therefore, do I take it that your evidence of your intention at the time was that the share transfer was not a condition of the TPA services agreement becoming binding?
I already answered. I said no. The way you're describing it, no.
No, it's not a condition. Thank you. If you may have already answered it, and if so, I hadn't understood your answer. And then, in relation to the licensing conditions.
In relation to, sorry?
Sorry, the licensing situation.
Yes.
So your position is that it was a precondition of the TPA agreement becoming effective that GLOBEMED have an unconditional license. I think that's the effect of your evidence. But you say that there was no express discussion of it, and we don't need to go over that. But just to understand the position, you are clear that what was in your mind was that the license had to be unconditional.
Yes.
I think if we go to your evidence here, page 371, go to paragraph 49A. I think what you say is, in the last sentence, my understanding at the time was that GLOBEMED would not be able to fulfill the TPA agreement unless they received all and unconditional regulatory licenses. And then you refer to a document at 49B marked DHA project launched. GLOBEMED made various representations about the fact that GMGFZ was already licensed and that it was just a matter of time before GLOBEMED obtained the unconditional DHA license and the required hard license. It later transpired that this clearly was not the case. Now, the document you refer to is at page 1688, so can we just have a look at that very briefly? So that's the document that you are talking about, DHA project launch. Is that right? That's what you meant?
Yeah, I guess so, yeah.
And is this a document you found during the course of these proceedings? It's not presumably something you remember.
Yeah, I don't remember, yeah, I think during the proceedings.
Very good. And so you weren't, when you went into the January meeting, you didn't have in your mind things that had been said in this document, did you?
Sorry, I didn't get the question.
When you went into the January meeting,
yeah,
and people were having those discussions, this is not a document that you had in your mind when you were sitting in that meeting?
No.
It's not a document that was discussed between you at the OIC level?
No, it wasn't.
In fact, it looks like this is a document which is about GLOBEMED Gulf FZ, which is the free zone company. That's right, isn't it?
Yeah, it looks like it, yeah.
And so when it says, you see, I think the paragraph you're probably referring to is about the middle of the page. You say, in Dubai, the company received its conditional health insurance permit approval, with complete approval received from the Dubai Health Authority on all technical documentation and compliance commitments. And then you see the quotation about that follows from the chairman of GLOBEMED Gulf FZ, L.L.C. So actually, this document is not about the claimant at all, is it?
So,
your evidence, you relied on this evidence.
Yeah.
In your evidence, you rely on this document
right.
to suggest that the
right.
claimant was making claims about its licensing status. But in fact, this document is making claims about the licensing status of the offshore company, isn't it?
I believe so, yeah.
So it doesn't actually say anything at all about the licensing status of the claimant, does it?
But I remember that they were facing issues in obtaining a conditional license from the DHA and a license from HUD as the onshore company.
But that came after the January meeting, didn't it?
Yes, it did.
So at the January meeting, and this is what I'm trying to get to,
right.
when these documents were signed, nobody had any doubts about... Well, hold on, just wait for the question, sorry. Nobody had any doubts about the claimant's licensing status, did they?
No.
So
Can you clarify? No, it means no, there is no doubt, or there is doubt?
If I want to explain it again,
We don't need to get to that detail. Just clarify the answer. because for
no,
me,
I did not have doubt because I assumed that they are supposed to have license or gonna be having their licenses.
I think the document that you're thinking of, if we go to page 2619, see there in the middle of the page, there's a report, and it says we have the results. This is 18th of February, so it's about a month after the January meeting, yes?
Yep.
And there's a report from Mr. Ashraf to various people. You are copied on this, and it says we have the results of our HIP registration with DHA. This time we are graded under conditional compliance, which is attributed to the TPAs that we had registered as part of our submission. Is that OIC saying we've got conditional status then because of the TPAs?
Yes, I guess so.
And is it right then that in February, that is the first time anybody suggested that GlobeMed might have some sort of conditional status?
Yes, so.
Presumably, I think you quite fairly say you don't really know what the reasons for that conditional status were. Is that right?
I don't really understand your question.
Is it fair to say you don't know why GlobeMed got a conditional status in February?
No, I don't.
I won't ask you any questions on that. Let's go back to the meeting, if we may. Now, can we go please to page 2130? Now, you see there the email that's sent by Miss Patricia Atala. So that's in the middle of the page. It's the final email on the page. Do you see that email?
Yes.
And that is dated 13th of January 2015, and it says 7:19 p.m. In fact, it's right. Do you recall this email? You recognise this email?
Yes.
It's right that this email was sent about 15 minutes after the meeting broke up. Is that right?
I guess so, yeah.
You don't remember?
No, I don't remember.
Ms. Atala was explaining that when it says 7:19 p.m., the distinction between time zones accounts for some of that time, and therefore it could have been 10 or 15 minutes after the meeting.
I don't remember.
Now, what she says here is we missed to complete the starting date in Article 12.1 of the agreement in the signed versions of the TPA agreement. Kindly add these on your copies in the handwriting to read 13 January 2015 as we agreed. The same will be adjusted on our versions. So she says we have agreed this, and I'll come back and ask you some questions in a moment. But above that is the response from Ms. Fidel.
Yes.
And she says, considering that we added the BUPA clause with a 1-month period to get written approval from BUPA, the agreement can only be effective from the date the approval is obtained. So was your understanding of this email at the time that she was saying that is the effect of clause 15, what's been called the BUPA clause in the MOU?
Yes.
She's not saying there's some other mechanism which makes the TPA services agreement subject to BUPA.
It does not say that.
Which she's not saying that, no.
She's not.
No. All right. And then, as I say, Ms. Atella said in her previous email as we agreed, please insert that 13th of January 2015 date. Now, you say in your evidence that you don't remember any discussion about inserting that date.
Yes.
And that remains your position.
Yes.
So you're not able to say, for example, that it was deliberately left blank.
No, I wouldn't say that.
Now, would you accept, though, that there must have been some discussion of that clause if it was deliberately left blank?
No, I don't remember we have discussed it or whether we have deliberately left it blank.
But what I'm saying is that had you deliberately left it blank, then you would have had a conversation about it, because one doesn't normally have lawyers and leave a contract term blank without talking about it.
Yes.
But given that you can't recall any discussion about it, would you accept that it is far more likely that it was just left blank accidentally?
Possibly.
And if you had disagreed with Mr. Taller's statement at the time, but in fact you'd agreed to insert that date, you would have remembered at the time, 15 minutes after the meeting, whether that was true or false, wouldn't you?
I would have, yes.
And so we see that Ms. Atala was saying it at the time. If you had seen, well, you did see that email. If that email had been wrong and you hadn't actually agreed it, you would have come back and said, well, no, that's not correct, wouldn't you?
But Ms. Hajar answered, so I saw no need for me to answer.
But don't you think that if somebody had said, look, we have expressly agreed to put this date in, then just thinking back to the time, just come out of the meeting, it's 15 minutes later, and somebody is saying something that's not true, that would be cause for alarm, wouldn't it, for you?
Well, this is why she wrote back, considering that we added the BUPA clause with a 1-month period to get written approval from BUPA. The agreement can only be effective from the date the approval is obtained. So when I read Ms. Fadl's reply, I saw no need for me to get involved.
But there's two issues, aren't there? One is, as a matter of fact, did you have a discussion about clause 15.1, sorry, clause 12.1 of the TPA services agreement and agree to put a date in there? And the other is, well, we agreed on clause 15, and this is what I understand to be the
I don't
effects.
remember that we had that type of discussion.
I understand. And what I'm trying to get to is, had somebody made a false factual assertion about the existence of an express discussion and an express agreement a mere 15 minutes after the meeting, you would have said something, at least behind the scenes, to your colleagues, because it would have been hugely alarming if someone was lying about this.
But I think we only saw this email is later on, and when I opened, maybe I opened it the next day also, maybe not the same day. I'm someone who sleeps very early, especially coming back from a business trip. And I saw that reply, and I was comfortable whether this is alarming or not. But I do not remember that after 15 minutes I've read this or...
But if we go up the page to page 21, so we're still on 2130, but if we look at the email from above, if you can see from the previous page that this is a response that comes back from Mr. Saliba. And again, you're copied in on this. And Mr. Saliba says, "Dear Hajar, this was previously discussed and agreed, and we will not go back. The agreement takes effect as of signature. The BUPA clause will not affect our mobilization plans." So just pausing there, there's obviously perhaps a discussion about the effect of the BUPA clause on the TPA services agreement. We can have that argument in front of the judge going forward. What I'm asking you about, what actually was discussed and agreed at that meeting. So here, Mr. Saliba is saying this issue, this date, or the effectiveness of this agreement was previously discussed and agreed. Now, if he was saying that the day after you concluded that meeting, and it was false, surely you would have come back and said, no, that's not an accurate recollection of what happened.
I actually don't remember that this discussion happened, genuinely. And I, again, rely on what Ms. Fadel replied back. And this is where I believe that we wanted to leave it there.
You, at least from this email, that the claimant's position at this stage was that there was a finalized agreement. And Mr. Saliba reiterated that position, and then we get the response from Ms. Fadel. Do you see that on page 2129, please? She doesn't come back. She doesn't answer Mr. Saliba to disagree with that fundamental point. She says, in order to get the approval from Bupa, we've been requested to share some of the due diligence materials with them. I'm requesting your permission to do so, subject to Bupa signing an NDA. So she doesn't dispute what Mr. Saliba said. Now, did you have a discussion with her about what was being said by Mr. Saliba?
I don't remember having a discussion. Maybe she, as a matter of fact, she just picked up the phone and called me and she said, did you see what Roger answered? And I said, yes. And it was left at this point, at this stage.
Surely, being a lawyer, literally the day after the meeting.
And being a lawyer, maybe I'm not that good in your eyes, but being a lawyer, I thought that what she answered Ms. Atalla was sufficient to basically express our intention.
One moment, please. All right. And then the agreement goes forward. So your position is that you didn't think that any of this was binding until Bupa came into the picture. Is that right?
That's my understanding, yes.
All right. And then we get on with the next steps. One of the next steps we see at bundle page 2155. All right. Actually, we should start on page 2156. This is an OIC email from Mr. Simon Peter Santaspirito. Could you tell us what his role was?
I don't really remember his role, but maybe he was from the project management team or the IT team.
I see. All right. And so he is emailing you the day after the documents are signed, amongst others. You'll see Abhishek Kishore, and then you are the third person named. And it says, Dear GM OIC project team, building on the work you have been doing with Vlad and Ellie, please find attached a proposed task list to enable a contractual agreement between OIC and GM. Do you see then down below, I don't know if we've got the attachment to that, but then you can see on the previous page the answer to that from Mr. Kishore. He responds, do you see the, Dear SP, on the legal tasks have attached the feedback, and the first line says intercompany OIC and agreement, Anwar Hajar, and then it says legal feedback, the agreement with GLOBEMED and GMGS have already been signed. So the question is, what do we need to do to get to a concluded agreement? The answer that comes back is nothing, it's already been signed. That's what Kishore was saying at that point, isn't it?
Okay.
Is that right?
That's correct.
Right. So your understanding was that there was no further contract that needed to be signed?
No.
Now, and at one point, the parties agreed to make a press release.
Yes.
And I think the draft, we see at page 2265.
Yes.
You see there, it says, GLOBEMED Gulf Healthcare Solutions signs new agreement with Oman Insurance Company. And then further down, about in the first paragraph, if we look 3 lines up from the bottom of the first paragraph, it says, this agreement will allow OIC, as a leading insurance provider, to benefit from GLOBEMED's vast healthcare management experience and state-of-the-art technologies to further enhance the services it delivers to its clients. Then the third paragraph starts, the agreement between GLOBEMED Gulf. Now, those are your comments on the document, aren't they?
Yeah, I guess so.
And you were happy, therefore, with the first half of the document, weren't you?
I wasn't happy with the overall of the wording, but then I said in the email that if this needs to be released, I would I would recommend those changes.
Well, if we go back to the previous page, what actually you say is, I'm not comfortable with the second part of the press release. You then say, I would request you to seek more time until we finalise with Bupa. So going back to so your problem was with the second part of the press release, not the first part of the press release.
Yeah.
You would have been happy for the first part of the press release to go out.
Yes.
So if we look across, back again at 2265, you would have been happy
Yes.
because they had.
Yes, because those were the intentions back then. So things have not yet came up to or surfaced. So we signed the agreement in January, and we went back to Dubai on the basis that we need to start the implementation. So all intentions were towards completing this agreement, this transaction.
Yes, but my point is that there's an argument about whether or not the contract was binding or not. Wouldn't have told the market that you had an agreement if you didn't think that, at least at this time, you didn't think there was a binding contract in place.
Yeah, considering the Bupa arrangement, which I expressed in my email, because again, it is clearly mentioned in the MOU that the numbers will be renegotiated.
Well, actually, I don't know whether you're changing your evidence here, because I think what you agreed with me a little earlier was that you would have, if you'd cut off the second half of this press release, you would have been happy for that to go out. You said that to me. You agreed that with me a moment ago.
Yes, okay.
Right. So that, in your mind, was not conditional on Bupa.
Looks like it wasn't.
So you would have been happy to announce an agreement to the market which wasn't conditional on Bupa.
Sorry, I have to interrupt you. I need to check with my... Same problems happen. I need to follow the question and answer. I cannot follow.
Of course not. And if you'd like to take a break, we're in your hands. This is moving quite quickly.
Going to break anyway by 1 o'clock. So. Back now. Sorry for that. Please carry on.
Right. Going forward then to February 2015, and I'll just see if you remember this at all first. Behind the scenes at OIC, you within the legal team drafted up a proposed amendment to both the TPA agreement and the MOU. That's right.
Are we talking about this press release?
No, I'm moving on from the press release. I was just seeing
okay.
if you remembered.
Yeah.
Later on,
Right,
yeah.
yeah.
So let me show you. It's at page 2586.
Yes.
And it says, Dear Hajar, as requested, please find attached the required amendment addendum to the GLOBEMED's MOU and the TPA agreement. So that's dated 15th of February 2015. That's from Mr. Kishore, again, your number 2, to you. And so there were discussions there internally in OIC about amending both the TPA and the MOU.
Yes, it looks like it.
And those didn't actually get so far as making proposals to GLOBEMED, did they?
Yeah, I guess so.
Or you think they did?
I don't know. I don't remember. I
I see.
don't remember.
But if we look at what was being amended, you see there, page 2587. And then it says this addendum to the TPA services agreement dated 13th January 2015 is made on, and then a blank date, and then February 2015. So you see there that the people, you included, who are drafting this document acknowledge the existence of a TPA services agreement dated 13 January 2015, yes?
Yes.
And let's just look at how you wanted to amend it. So clause 5.1 was going to be amended. And what was said was, subject to the certain exceptions, you don't need to deal with those, the client shall contract and work exclusively with GLOBEMED in all what relates to the third-party medical claim administration services as agreed in this agreement, and then excluding the portfolio related to Bupa, and then it defines it as the Bupa portfolio. So whereas the original terms of the TPA agreement include expressly the Bupa portfolio, behind the scenes at OIC, you were going to propose an amendment to that agreement to exclude the Bupa portfolio.
Yes.
So without this amendment, your concern was that under the TPA services agreement, OIC had to transfer the Bupa portfolio, was obliged to.
Let me put it this way. I was just being more precautious. Just trying to mirror the entire transaction together.
Because your concern was that if you took the TPA services agreement by itself, in isolation, your concern was that it required OIC to transfer the Bupa portfolio in circumstances where Bupa hadn't yet agreed to it.
Potentially, yes.
Well, not just potentially. I mean, that was the effect. Your understanding of the effect of the language in the TPA agreement.
See, I'm a legal person, and we try to manage risks as much as we can. This was reflected in the MOU, and we thought it would be even more precautious to have it within the TPA as well.
Well, let's look. I mean, firstly, if we can go to page 2588, clause 4, and there the drafting of this proposed amendment acknowledges, doesn't it? I'll read it out for you. The parties agree that except for the amendments as stated in this addendum, all other terms and conditions of the TPAA remains valid and binding on the parties. So, taking it in stages, before any amendment, you would therefore presumably accept that the terms and conditions of the TPAA were valid and binding on the parties.
Again, I saw that it could be potentially a risk, and I wanted to mirror the transaction to be at the same page with the MOU.
You weren't saying that they would become binding in the future once a share transfer took place, or once
I did not say that, no.
That's because you knew that they were already binding at this stage, yes?
I honestly, I saw it as there was the condition, and for me, no, they were not yet binding. At least now I can see that they were not binding.
But that, I mean, contracts impose obligations on parties,
Correct?
but only if they are valid and binding, yes?
Subject to fulfillment of certain conditions.
Well, sometimes contracts say that there are preconditions, but you accept that there was nothing like that in this contract.
Correct, but if there are conditions that are not fulfilled and that may render that that contract impossible to perform, then it could be a problem, yes?
Yes, it would be a problem, but the way that that problem would arise is you would say to your counterparty, you promised to do this, you didn't do it, you're now in breach of contract.
Right.
That's the analysis. You're a lawyer, that's the analysis.
Sometimes
yes?
conditions are not based only on one party breaching. Sometimes conditions are, as a matter of fact, BUPA was a condition. The license could have been a condition. What if the authorities did not grant GLOBEMED the license?
Well, then presumably you would have said you're in breach.
Presumably the contract could not been performed for both of us.
But it wouldn't mean that the contract suddenly vanished, would it? Contracts don't suddenly vanish when somebody's in breach.
But it's not possible to implement it and to perform it.
Well, let's look at the MOU draft amendments that you were proposing to implement. See there, it's on page 2589. And it refers again at the top of the page, do you see, to the Memorandum of Understanding dated 13 January 2015. And so if we look at what you are trying to amend here, say, whereas, do you see in the middle of the page? Whereas, the parties have entered into a Memorandum of Understanding whereby the parties have agreed to share the equity and so forth under the MOU. As BUPA's written approval to transfer its portfolio to GMGS is still awaited, partners do not wish to wait for the transfer of the portfolio, which is currently being serviced, and proceed with the MOU based on this investment entity's current medical portfolio, excluding the BUPA portfolio. And then it goes on to seek in 5B2 and 5B4A over the page to try to propose a draft which would exclude the portfolio from the scope of the MOU as well. And so now none of that resulted in an agreed contractual variation.
I don't think so.
But can I ask you to go forward now in the bundle from there to page 2817?
Yes.
I need to find it in, for those who've got bundles split up, I think it's F2. You see there an email from Ms. Fidel. Again, I don't think you are copied on this, but I want to ask you, I want to show you what it says and then ask you about what the understanding of the position was behind the scenes in OIC. So what she says is this: team, while a lot of work is going into this transition, the reality is we are behind schedule on too many fronts, and it is imperative that everyone deliver their part in accordance with the project plan. And then do you see the list of important considerations that she identifies? Paragraph 1, even if we agree to push the go-live date because we're not ready, this doesn't guarantee that OIC will not pay the TPA fees for May the 1st. This will be a direct hit to our medical P&L, and we won't be in a position to argue this if many of the delays are caused by OIC. So is it right then that within OIC there was concern that if there was delay to go live, which was the fault of OIC, OIC might have to start paying fees under the TPA anyway?
Looks like this was Ms. Fadl's understanding.
Right. But so you weren't involved in any of those sorts of discussions then?
No, I was not.
Doing the best we can as to Miss, she's not here, but Miss Fadel's understanding, that would suggest that she thought, at least, that the contract was binding, generating fees, regardless of what happened next, by this point in time, which, as we see, is April 2nd. You accept that as a characterization of what she appears to have understood?
This is her understanding. Looks like it, yes.
And given your discussions with her about this, presumably that is consistent with your understanding of her view of the contracts?
I don't remember having a discussion around this in particular, but I remember that she was very adamant in having this transaction going through. And I remember maybe in one of her emails, she was saying that we'll start with the OIC portfolio, and until we get the BUPA approval.
Yes, I see. And in fact, that's what the amendments in February were intended to achieve.
Yes.
But the point I'm making here is that she appears to think that fees are going to potentially become payable by early May.
This is what she's saying, yes.
And I'm asking you, because we don't have her here today, we don't know where she is, from your discussions with her, so if she thought that, then she must have thought that the contract was binding from what May. And so that, in her discussions with her, that must have been the view that she expressed to you.
I don't recall having a discussion around this topic in particular.
And one of the things that had to happen to reach Go Live is that the network had to be informed, the healthcare provider network. And if we go to page 3068, again, I think that this is not, it may or may not be, an email that you've been copied on. I don't know whether you've seen this before. Do you recognize it?
I don't really remember, but I remember that there was some kind of communication that was supposed to go to the provider and to the network.
Yes, and so were you not? You weren't involved in that?
And some of them, yes, I was.
I see. All right. So, well, this appears to be the email where a circular was sent around to the providers, and it says, we have amended our existing provider agreement that you have with Oman Insurance Company to reflect our cooperation with GLOBEMED Gulf Healthcare Solutions as a TPA for the management of our network. And it says, please refer to the subject in the attachment for details. And then you have attached to that, the following page, 3069. Do you recognize that circular? I think it went out like that, not in Arabic. So.
Yes, I am.
Recognize that?
Yes.
You do. You know, I think, that in the first full paragraph of that letter, now in March, it says, with reference to above subject, Oman Insurance Company has contracted with GLOBEMED Gulf Healthcare Solutions, a third-party administrator, to manage part of OIC's healthcare insurance portfolio, and has accordingly assigned the agreement to GLOBEMED Gulf. So that is accurate, isn't it? By the March 2015, you would accept OIC had contracted with GLOBEMED.
This is what it says.
But that's the position as well, isn't it?
It is.
And we see at the end of that document on the following page, page 3070, third paragraph down, kindly note that this document will be attached to and considered an integral part of the existing service agreement between OIC and your facility, unless a written objection to this document is received. what you're doing, what OIC is doing, is they're sending out effectively new terms or a variation of the terms and saying, please agree, but if you don't agree and you don't disagree, we're going to take it as acceptance. Is that right?
No, I think we said that. We said kindly note that this document will be attached to and considered as an integral part of the existing service agreement between OIC and your facility, unless
Yes.
a written objection to this document is received from you within 7 calendar days from the date of receipt of this letter by your facility.
Yes. So unless they come back and say we object expressly,
Yes.
you're going to treat them as having consented.
Yes.
You're amending the terms of
Yes, I
all
am.
of these provider contracts. Do you know how many there were?
No, I don't remember. No.
Hundreds.
Possibly yes, but I don't know. I don't have the exact number.
And then if we go to page 3136, see there an email, sorry, 22nd of March from Barnabas, I think it is, of Med Network, various people saying, "Dear all, this in reference to the above subject line, I'd like to inform you that with the above communication shared with all providers today, OIC network management has been transferred to GLOBEMED, effective 22nd of March 2015. And then there's talk about the runoff of that. So you would accept that the network was transferred to GLOBEMED?
Yes, as per these arrangement, yes.
And you're also aware, I think, that staff were transferred from OIC to GLOBEMED?
I know that I think 1 or 2 were transferred.
Right. Well, we've got. I think there are a few, but I can show you them if you like. But you accept some staff were.
Yes, some. What I know, I remember it was 1 or 2, and I know that there was maybe a list of 50.
Yes, I see, but that hadn't yet happened.
But it did not happen. Yeah.
You are picking that information up from the documents, is that right?
Yes.
It's not something that you were aware of at the time.
No.
But I think isn't the point that unless there was actually an existing binding contract in place between the parties, that would never have happened. You wouldn't have started moving staff from one party to the other, would you?
Me personally, or?
OIC.
OIC, yeah. OIC they wanted to go live with this transaction.
And it's right, isn't it, that actually OIC even agreed to make an advance payment in relation to the TPA services agreement. Were you aware of that?
No, I don't remember this.
Show it to you briefly. It's at page 3619. You can see what you've got on 3619 is an email from L.L.C to Mr. Taldana. And he's the CFO, did you say, of OIC? Chief Financial Officer,
yeah.
Yes, okay. And Mr. L.L.C is asking a number of questions and asking for responses. And you can see from the previous page that Mr. Taldana has commented in blue. So the text, the black text is Mr. Tomey from GLOBEMED. The blue text is the response from OIC. And so what's said is advance of payment. Do you see paragraph 1 there?
Yes.
As discussed, G-Gulf is facing significant cash requirement, and then said, in the span of this week, due to high expected spending related to ramp up before go live, with a key consideration being the expected spending for the new office rent and fit out costs. You mentioned that in principle there was no objection to advancing the first quarterly payment of fees from OIC to GLOBEMED Gulf before the go-live date. Would appreciate your confirmation on when would be the earliest you could arrange for this advance. And the answer comes back, this is okay in principle. When were you expecting the cash? Now, does that surprise you that OIC was going to provide cash in advance?
A little bit, yes.
But I think what I'm getting at is that within OIC, even at this management level, even at the CFO level, everybody thought this was a binding contract, didn't they?
When you say everybody, you mean by who exactly? Everybody, even?
In your discussions with the people who were involved in this contract at the time. Well, clearly from this, Mr. Taldana, if he was here giving evidence today, he would be saying, of course I thought it was a binding contract. I wasn't going to give them an advance on a contract that wasn't binding. So he must have thought.
Unfortunately, he's not here to confirm this.
Did you have any discussions with him about it?
No, I haven't.
Have you tried to get in touch with him?
No, I don't remember whether I needed to.
Made no attempts to see what his view, his understanding of the contractual position was.
No, what? Not at all, no.
Mr. Smith, we're supposed to break out in 5 minutes, so how long?
Yes, in fact, I'm getting to the end of a topic, and let me just check my notes, and then it may be that we can do it. I was about to move on to a new topic, actually, so if now is a convenient moment. Rise now. In terms of a progress report, we're moving quite quickly. I would expect no more than half an hour. Maybe less.
Ask a few questions before we break in 5 minutes, so you want to break?
I can move on to a new topic, but then we'll split it up so we can break now if it's convenient for Your Excellency.
Much better to break now and come back in 2 p.m. for continuing. Right, thank you very much.
Can I ask that you be shown page 378 of the bundle, please? It's your witness statement, paragraph 71B. Just a quick question on this. You say, if you have it up there, paragraph 71B, in the middle of that paragraph, you say a committee or task force was established comprising of OIC and BUPA personnel. Presumably, there would have been reports that were generated by that task force?
I assume so, yeah.
But you had no involvement in that?
I wasn't really part of it.
So when you make comments in your witness statement about your understanding of BUPA's attitude to this transition, your comments are based on the documents, are they?
It's based on the documents, and see, in Oman Insurance, there was a lot of things happening back then. So there was always a talk, and I used to sometimes pick up the phone out of curiosity and ask Hajar, how's it going with the BUPA approval? Is it going on? And there was always an answer that they are still looking into.
Yes, I see. But for example, if you look down the page on this same page, paragraph 72, yeah. When you talk about these things, you say it's based on your review of emails that you have now seen. So you were not seeing those emails at the time, is that right?
I don't remember that. I may have been copied, but I wasn't really looking into these.
Well, one document you weren't copied on, but you probably would have been aware of at the time, I think. If we go to page 2542. An email from Ms. Fidel. The various people, but it doesn't look like you're on this email list, but it says feedback from BUPA. Do you see that?
Yeah.
And so this is the 11th of February.
Right.
So about a month after and you'll recall that the so-called BUPA clause, the clause 15, anticipated that could be consent from BUPA within a month.
Yes.
So what Ms. Fidel is saying, paragraph 2, she says at this point we see no need to reopen any discussion on the MOU in terms of section 15. We'll therefore proceed with the transition of our own portfolio as planned, and we'll revert to you when BUPA's final decision is known. And then above, sorry, I missed out this bit in the first paragraph. She says, second line, while their overall feedback has been positive, Bupa has not yet made a go, no-go decision. So presumably that's consistent with your sort of general understanding at the time of the attitude of Bupa, that their feedback was positive.
Honestly, no. I can't tell whether it was a positive feedback or a negative one. It's, at least this is what she's saying, and but no, I haven't had any feeling about it, whether it's positive or not. But I know for a fact that they were asking a lot of questions and there were lots of back and forth.
Yes, all right. And you know, by all means, if you just don't know the answer to the question and you don't have any insight into the topic, just let me know. But I thought your evidence was your understanding of the attitude of Bupa was based both on the emails and on discussions that you'd had in the office.
No, I can't tell, honestly.
You can't remember any discussions with other people in the office about Bupa's attitude?
No, I can't remember.
You can't remember any?
No, I can't remember.
I see. So going back to the question I asked at the outset there,
yeah.
Your understanding of Bupa's attitude towards this transition is based entirely on the documents that you've read then?
Yes.
Thank you. But we can see here, well, were you aware of this? If we go to page 2893, bundle F2 for those who've got their bundles split. This is an email from a little bit later in February, and I'm showing you it not because you were copied on it, but just to see whether you were aware of this particular problem in the background. So do you see there's an email from Lucien to Patrick Choffel answering an email earlier from Patrick Choffel. Sorry, an email from Lucien to Patrick, and then Patrick's response is in, Hajar's response is in blue. That's what it is.
So what I see in front of me is an email from Ms. Fadel to and Mr. Agramas, copying Mr. Panda, Dr. Panda.
The 2893 you're looking at.
Yes.
So I've got Mr. Fadel to Mr. Lucien Lataif. I seem to have a wrong bundle, not even a reference. What was the number? Four. Oh, I see. Yeah. Could you please turn to 2894? Thank you. I have no idea why I'm one out. It's very strange. I must be missing a page somewhere. It's probably the critical one, but there we are. My fault, not yours. All right. So if you're looking at the same, at the top of the page, you've got an email from Hajar Fadel to Mr. Lataif, and it's a response to Mr. Lataif's email to Patrick Choffel, lower down the page. And so it looks like the black is Mr. Lataif Jr., and the responses, which are in blue, come from Ms. Fadel. Yes?
I believe so.
Very good. And so what she is, the question is, firstly, dear Patrick, as discussed, the areas we need to clarify and elaborate further are the following. Number one, position of Bupa in using GM Gulf services. And then the answer comes back, the first members of Bupa UK will be in place next week to start the second round of discussions. As communicated before, they've not made a decision and their overall feedback is positive. And then she says, frankly, we have no reason to believe that they will not join. And then we can see over the page, which you probably have on 2895, the question is raised as to the cost implications to the operation. And it says this, the delay of Bupa has no financial impact on GM Gulf over 12 months. GM Gulf will require less headcount to scale up its operation. Bupa portfolio transferred at a later date, while they receive the same TPA fees of 33 million we agreed on, and which was taken into account, GM Gulf handling both OIC and Bupa portfolios. On the opposite, this increases runoff costs for OIC, as we need to maintain staff and systems for a longer period to service the runoff of Bupa. So you may not be aware of this at the time, but I'm asking you if you were. It looks like the potential for Bupa transferring its portfolio later could cause cost implications to OIC, presumably because they'll have to be running effectively two claims management books at once, one themselves and one through GLOBEMED. Was that a concern that you were aware of at that point?
No, I wasn't.
We go to page 2904, Hope. What I've got is an email dated 2nd of March from Ms.
2nd of March, yes.
Yeah. And if you look at the email below from Partha Panda to Hajar Fadel, there's a look at the bottom of the page, from Samir Sawaya from Bupa, coming back to the OIC team, including Andrew Brody. Further to our conversation last week, thank you for updating us about the transition of the provider relationship from OIC to GLOBEMED, over the page, starting 10th of March 2015. For clarity in my understanding, OIC will retain the ownership of the contracts for now, and then we can skip the rest of that paragraph. And the next one, this is Bupa. This is all fine and agreeable by Bupa Global. Please arrange for a weekly report to be presented to us so that we can go over the results together and gauge the success of this transition. So it looks like by the 1st of March 2015, Bupa is completely happy with the principle of the transition. They obviously have some concerns that need to be hammered out. But it looks like by then they are effectively content and everyone's happy that they will eventually come across. You accept that as being the position behind the scenes in OIC and their understanding?
I wasn't, this is honestly maybe the first time I see that email. I didn't get the chance to go through these communication, but up till the end, I had the understanding that Bupa was still not on board. Now, whether, I know they also, I never heard that they were not happy or whether they are happy. All I knew, as I mentioned before, is that they had a lot of questions.
Yes, I see. So you didn't go through all the documents then?
Not all the documents, no. I may have missed some documents, of course.
Right. It's just I'm looking at your witness statement, page 3878, paragraph 71. And you refer to having reviewed some documents. In 72, you say, based on my review of emails, which I've now seen. So was somebody else collecting up those emails and documents for you, presenting them to you in a pack, and then you've gone through them and drawn your own conclusions from those documents?
So after, when we were drafting my witness statement, we were referring for some of the communication that I was aware of, and just to refresh my memory, and how I was looking at the documents. But to have a full review of all the documents of the entire case, no.
So now that we can do that, we can probably base our understanding of Bupa's intentions from these documents, and not really from your own review, yes?
Your understanding, not mine.
Now, can I show you one other document, because it is relevant to your position, which is 3391. So, again, you're not involved at this point on this correspondence, but it gives us an insight into what's going on behind the scenes at OIC. You've got an email here on the 19th of April, Eli Tomi, sent to Hajar Fadel. So that's GM emailing OIC. And it says, Dear Hajar, in reference to our discussion of earlier, please find attached the accruals basis projections that were requested by PJ. This is likely what will be up for discussion between Patrick and Mooney. These projections are based on end of May, with Bupa starting in September 2015. So the reference to May is the reference to go live, isn't it, of services?
Okay.
Would you agree?
That was what the anticipation, yes.
And then the anticipation appears to be that the services will commence in May, but that Bupa will not start until September 2015.
I think this is what it says here? Yeah,
Yes,
starting in September. Yeah, with Bupa starting, yeah.
So by this point in April, the anticipation is that Bupa will come across after services have commenced.
This is what Mr. Tommy is saying. Yes.
And you disagree with that, do you?
I don't know.
If that is the position, as it appears to be, then there could not have been any expectation that Bupa would actually transfer its lives before the contract came into effect, could there?
I honestly, I cannot answer that question.
Don't know. Okay. And in fact, the plan was to resolve the discussions with Bupa after go live, wasn't it?
Again, this is what is Mr. Tommy saying. Yeah.
Well, if we go to bundle F, it's F1 for those with a split bundle, page 1456. The project schedule that was produced during the cross-examination, well, sorry, it's been produced previously, but mentioned in cross-examination yesterday. If we look at this, this is a project management schedule, I think produced jointly between the parties. But either way, if we look down to the bottom of this, page 1456, you see there a heading Bupa, line 407.
407, yeah.
Did you see the heading Bupa there?
Yeah.
So the date range there is the 1st of November 2015 to the 10th of December 2015. And you'll see line 408 says OIC departmental L2TOM discussions. 409 is confirm OIC L2TOM with GM and Bupa. And then SLA discussions. And then confirm various SLAs, service level agreements, with GM and Bupa. Create SOP for all Bupa processes. Review and confirm impact, approval, legal review, and then presumably contract. So doesn't that show that the intention was to firm up the legal position with Bupa in that date range between November and December 2015?
May I ask who prepared that? I'm not familiar with that document.
Looks like this is a joint document prepared by both parties, but its truth was relied on. I don't think anyone doubts its accuracy.
Honestly, I'm not familiar with the document itself, so I can't really comment on it.
Well, I'm asking you about what the reality was on the ground. From this document, it looks like the plan was to resolve the position with Bupa in November and December 2015. Was that really the plan? That was the plan, wasn't it?
This is what it says here, but I cannot confirm that.
You just don't know?
I don't know. I'm not in that position. I'm sorry.
But do you see what I'm getting at? Your position is that the contract doesn't become effective until Bupa confirms that it's happy with the transition. But here we're looking at a document that says, A, the transition will start in May, and therefore the contract becomes effective. And then only after that, in November and December, will the position with Bupa be confirmed. Do you understand what I'm getting at?
I totally understand what you're trying to get, but also please try to understand what I'm trying to say, is that the condition of Bupa's approval had to be in writing. It was something that I needed to see in writing from Bupa approving that their portfolio would be a part of the entire transaction. This is my understanding. And what happened then was there were a lot of discussions happening between Bupa, OIC, and GLOBEMED, that I was not part of these discussions, and trying to convince Bupa to get on board. Now, whether they were happy, they were not happy, they were convinced or not, they had worries or not, I can't really confirm. My personal feeling is if it's taking that much time, then there must be something that is not, they are not really happy. But this is my personal opinion.
That's just your opinion.
My personal opinion.
Which has no, and you weren't involved in the relationship,
I
so
was
you just
not, no.
can't know what the reasons were. But my point is that you say there had to be confirmation in writing from Bupa.
Yes.
And my point is that if they were going to seek that confirmation in November and December, but start services in May, then the written confirmation you required from Bupa can't have been a requirement for the commencement of services, can it?
So maybe this is why we had proposed the amendment.
But do you agree or disagree with my statement?
It's not about agreeing or not. So the clause 15 of the MOU clearly states that if Bupa is not on board, the numbers will have to be renegotiated and discussed. Now,
yes.
This is a document that you're showing me that has a schedule, but obviously it is being prepared most likely jointly between Mr. Tami and Ms. Hajar, or OIC and GLOBEMED. And I don't see anything that tells me that even Bupa was part of preparing that document.
No, but this is about the relationship between the claimant and the defendant, because your position, and just do it one last time and see if you can follow the logic, your position is that the contract did not become effective at all until Bupa gave you a written confirmation.
Yes.
But we see very clearly here, in November and December 2015 was when they were going to get that written confirmation.
I'd never saw this.
You suggest this document could be wrong?
I'm not suggesting anything. It's the first time I see that document, and I can't suggest anything.
But if it's right, that indicates, doesn't it, that services are starting before Bupa gives a written confirmation?
I'm sorry, I cannot comment on that document. It's a document the first time I see. I don't know who exactly prepared it, on what basis it was prepared. Unfortunately, neither Mr. Fadel nor Mr. Tami are here to confirm these, but am I being asked to confirm something that I have not prepared?
No, what's happening is you're giving evidence about your recollection, and I'm showing you a document.
But I already answered. I'm not familiar with that document,
I know,
and
so
I cannot
just
comment.
wait for the question, so I can explain the process. If you need another chance, you can take it. If you don't want it, that's fine. You are giving your recollection. I am showing you a document which is inconsistent with that recollection. And I'm suggesting that the document is more likely to be accurate than your recollection. Do you agree with that or disagree?
Again, I cannot agree or disagree because it's a document that I don't know about, I'm not familiar with, and then I cannot agree or disagree with you. I don't know how it was prepared, on what basis.
In any event, I think you were aware that it was known that there was going to be, or could be, an overlap where OIC transferred lives to GLOBEMED, but that Bupa remained with OIC for a period. Were you aware of that?
Yes, I was aware because there's an email from Ms. Fadel saying that we might start by transferring OIC's portfolio to GLOBEMED.
Yes, all right. And that was going to cause a problem, wasn't it? Because it would be expensive for OIC.
This is where I cannot comment because I wasn't familiar of the commercial and the business side of it.
Well, tell me, you may not be able to comment on this either, but would you accept, or were you aware that really it was that caused OIC to bring an end to these arrangements, that prospect of having two parallel sets of claims management costs?
Sorry, I didn't get the question.
Would you accept that prospect, the likelihood that OIC was going to incur considerably more cost?
I cannot comment.
You don't know?
No.
Now, what you got was the occasional message from instruction from your board And we can see one of those, can't we, at page 3477. F2 for those with split bundles. So this is an email that you received on the 27th of April, 2015, and it comes from Mr. Al-Ghurair, yes?
Yeah.
And he says, and this is directly to you, please stop all the processes for GlobeMed partnership, as we will have second detailed review of this partnership. I've also instructed Patrick for the same. So in this email, Mr. Al-Ghurair is telling you to stop all your work on this, which would include your work on the share transfer arrangements, because there was a review that was going on. Yeah, and that's what you did, presumably. You just stopped. Yeah. And that's why you didn't go ahead with the share transfer, isn't it?
Yes, everything was on hold.
Because I think in your witness statement, the heading for it is GlobeMed's, a section of your witness statement is GlobeMed's failure to transfer the shares. But in fact, the share transfer didn't happen because you were told not to allow it to happen.
I honestly don't remember exactly on what basis why it did not happen properly, but I think also there was a failure from their side, I believe. If I've mentioned this, could potentially be because of that.
Do you think there might have been some failure on their side?
Potentially, yes.
But you're sitting here now today, you can't remember what that failure is?
No.
And you'll see there's an email in there that says a second detailed review. Presumably there was a first detailed review. Have you seen any product from that first detailed review?
No.
No reports or anything like that? Have you asked for it?
No.
And presumably you haven't seen the outcome of the second detailed review either. Have you asked the board members for any internal correspondence about why they brought this arrangement to an end?
No.
You haven't even asked?
No, I haven't asked.
And then we see on page 3665, please. A little bit later after the email, and it looks like what's happening is Bupa has got wind of the problem, and so they get in touch with Ms. Fadel and say, "Hi Hajar, hope this finds you with best of health. We've recently started hearing rumours around a potential hold or delay to the transition to GlobeMed related to the joining of the new CEO." So, did you hear that it was the result of a new CEO being brought in that was threatening this transaction?
Sorry, I didn't get that. The question again?
Bupa
Yeah.
have heard
Yeah.
that the deal might be on hold, and they say related to the joining of the new CEO. So from your recollection, was that also your understanding that the incoming CEO had a different view of the transaction that had been done?
I don't know.
And now, do you know whether or not OIC responded to that email? Have you asked?
No.
So,
The Thursday, May 14th, right?
correct.
Yeah. No.
And then if we go forward to page 3670, we see that is forwarded internally, but again, it doesn't look like you are copied on that. But it says, at PJ, please find out from Sandeep Nabil what is the status of their review recommendation. Who is Sandeep and who is Nabil? Do you know?
Sandeep was, I think, the Chief Operation Officer of Mashreq Bank.
Of
Mashreq Bank. And Mr. Nabil Wahid used to be the Chief Investment Officer of Mashreq Bank, and he used to be he is, I think, still a board member of OIC.
I see. So you've got two Mashreq Bank board, two Mashreq Bank personnel sitting on the board of OIC, or just one?
One, Mr. Nabeel.
I see. But between them, the Mashreq Bank end, they're doing some sort of review
It
and
looks
providing
like
some
it.
sort of recommendation. But you don't know anything about that?
No.
Have you seen that review in your?
No.
Have you asked anyone to produce that review?
No.
And then ultimately, a decision is made not to proceed with the transaction. Now, what that decision must have been discussed at length internally.
Not with me.
Not with you, I see. So if we go to page 3849,
Yeah.
see there's an email from Mr. Algarer,
Yes.
and he's giving that his email address is from Mashreq Bank, so he has a position at Mashreq Bank as well, does he?
His Excellency is now the chairman of Mashreq Bank, and he used to be the CEO of Mashreq Bank.
And so he says there, do you see in the second paragraph, making the decision to terminate this arrangement was a difficult one. So just stopping there. Oh, sorry. And he says, given the time, effort, resources, and passion both our teams have invested over the last year, we have debated internally at length the possible approaches for OIC to minimize costs and disruptions during the transition period, as well as the implications, financial, legal, moral, etc., this decision would have on both of our companies. So when it says legal, are you suggesting he had not in fact had any discussions with you about the legal implications of terminating?
Not at all. Not at all.
And you will see also, and again, you may not know much about this, but at the bottom of that page, you see the email that he was responding to.
Yeah.
See that Mr. Farron has said at the bottom, final paragraph, the main concerns you raised relate to OIC having to maintain a parallel team over a long period and the prohibitive cost in so doing. So presumably you don't know whether or not that was in fact OIC's real concern, commercial concern about this.
I'm not.
So is it then fair to say that this was a strategic decision that was made at board level and which took your team completely by surprise?
I did not question His Excellency about his decision, and I did not go into any type of discussions, whether with His Excellency or any other board member, regarding that decision. So I can't really tell.
But from your own personal perspective, it came out of the blue. No one discussed it with you. You've been working on it for a year, and then suddenly you're told, deal's off.
Yes.
And so it was a strategic decision imposed on you by the board, which took you by surprise, would you say?
It looks like it, yeah.
And is it fair to say that you didn't express your disagreement to His Excellency, but you did disagree with the decision, didn't you?
Neither nor.
You took no view on it at all? What about Ms. Fadel? She'd been working on it pretty much non-stop for a year. She also expressed her disagreement with it, didn't she?
I believe she was not happy, yes.
She was not happy. Not happy. And if we go to page 3875, please. What we've got here, if you scroll up actually a page, you can see what this is an email from Ms. Atala to various people on the GLOBEMED side, 25th of August, 2015. And so on page 3875, she reports a number of things that happened in the discussions that you had with her. So you were at that meeting, weren't you?
Yes.
And then she says, first bullet point on 3875, OIC understood completely our position and had no response or justification to defend what they did. Now, just pausing there, I mean, that's consistent with Ms. Fadel's view, wasn't it?
Ms. Fadel's view.
And so it's quite possible that she expressed that view at the meeting.
No, I did not hear that from her.
So you're suggesting that, so are you saying you don't know whether She said it, or you know that she didn't say it?
I don't remember she said it.
That she might have said it.
I don't remember at all. I would have.
And then if you see what you would have remembered, is that what you're saying?
So if you're talking about the second part of the sentence.
The first part of the sentence, start with that. So they understood completely our position and had no, well, yes, and the second part, and had no response or justification to defend what they did.
As I recall, we kept quiet. We did not give reasons, but we did not agree with the blame and the fact that we harmed them.
Well,
that was not expressed at all.
All right. Well, what Ms. Atala says here is that in the meeting, firstly, they fully agreed with the blame and the fact that they harmed us. And then do you see the third bullet point down? It says, in fact, Hajar and Anwar expressed to us that they disagree with their management decision to terminate, but they had no ability to object. Now, as we've said, that is consistent with Hajar's position that you discussed with her. She disagreed with the management decision to terminate, but wasn't in a position to do anything about it.
But I'm pretty sure that she did not express it.
It'd be a bit odd, wouldn't it, if Ms. Atala, I mean, you can't know, but you're working from recollections from years and years ago.
Yeah.
This statement is consistent with what you knew was in...
Yeah, but again, also, I know for a fact that this was not, or let's not say for a fact, but I don't remember at all that Ms. Fadl or myself said that we disagree with the management decision. This is something that I personally would never say, that I know for granted. Even if I was personally not agreeing, I wouldn't express it to my counterpart.
But do you think maybe in these rather extreme circumstances it's something that Hajar might have said, perhaps in a moment of lapse?
I don't remember that she said it in front of me.
All right, and then after this, if you go back, full, no, it is back to 3781, please.
Just for, how long are you going to need, Mrs. Smith?
I'm going to need another 2 minutes. So 3781, do you see there in the middle of the page is an email from you, Mr. Al-Khatib, and you're emailing Ms. Fadel and various others within your group, yes. And you are suggesting a draft email, and you say, this is an email that you are suggesting to send to the regulator, DHA. Yes. Saying, dear sirs, in our application for health insurance permit and participating insurer for 2015, GLOBEMED has been named as the third-party administrator. We'd like to inform you that Oman Insurance Company, OIC, have decided to undertake all administration in relation to medical insurance internally, and therefore GLOBEMED and OIC have mutually agreed to dissolve the third-party administration agreement. Now, OIC and GLOBEMED never did mutually agree to dissolve it, did they? They didn't, did they?
No.
So what you were writing out here was your understanding of what would need to happen to bring that arrangement to an end.
Yes.
And what you acknowledged needed to happen was that there needed to be a dissolution of the third-party administration agreement.
Yes.
And that would have to happen by agreement, wouldn't it?
Yes.
Thank you very much. Those are my questions. Thank you, officers.
Just a small number of questions, if I may.
Yeah. How long are you going to take? Just
5 minutes more. Mr. Khatib, could I just ask, what is your current employment status?
My current employment, I'm the legal counsel of SALIC.
And when did you leave the employment of OIC?
In December 2022.
Just to clarify, did you say SALIC?
SALIC, PJSC, yeah.
Want to just explain what SADC is very briefly?
Is this an area that was the subject of cross-examination?
No.
You need to lead more.
No,
Well,
just want to double check the typing. It's L-I-C-K.
SALIC is S-A-L-I-K.
Yes.
At 11:52 this morning, you said there was no discussion as to where the BUPA clause should go, but you say, I pushed to have it in the MOU. Could you just explain why?
I didn't hear properly, sorry.
You said there was no discussion as to where the BUPA clause should go, that I pushed to have it in the MOU.
Correct.
Just explain why.
Because I thought the MOU was the kind of the umbrella arrangement that will cover the entire transaction arrangement. As I mentioned from the beginning, for me, they were one single transaction.
Could we look quickly at page 1689? Learned friend took you to this morning. Could you look at the second paragraph? Refresh your memory. Remember, this is the project launch document.
Yes.
Which company is reference being made in the second paragraph?
It's GLOBEMED Gulf Health Insurance, Healthcare Solution, the new onshore entity of GLOBEMED Gulf. Trade license and has started operating from its new offices in January 2014.
Just focus on Ms. Fuddle. I'm moving on from this document now. Is it possible to say what you felt was the general level of enthusiasm of Ms. Fuddle for this transaction?
I think she was very adamant to have this transaction going through.
And lastly, you made a reference, or you suggested that was reference looking at the two agreements, the MOU and the TPA agreement. You said there was reference in one agreement to the other agreement. Gone quite quickly. Do you want to develop that or identify what you think was the reference in one to the other?
I can't recall, but I think there might have been some reference in one agreement to the other. I think maybe in the MOU, if I'm not mistaken.
Would it help to scan the MOU now? It is at page...
That would be good, yeah.
Sorry, it's at about page 12, 2095 from recollection. 2092. Ask the operator to move on to the next page. Helps or
I think in the preamble here, whereas GLOBEMED and investment entity are in discussion to share the equity of GMGHS as partners based on the terms and conditions of the present MOU.
that's this document, though, isn't it? That's not a reference.
This is what I'm trying to, honestly, I don't remember, but I've seen it somewhere that there was some reference or cross-reference, but I can't recall exactly where.
Thank you.
Thank you.
So I have no any further question for you. Thank you.
Thank you.
Shall we call now the...
Yes, so now we need to call Mr. Yusuf, who is my industry.
I'm going to need to change seats with my learned friend. It may be worth having 2 minutes just so that I can...
No worries.
Does your Excellency want to rise while we get Mr. Yusuf in? We're going to have to get his wheelchair up.
No worries, no worries.
Oh, he's gone. It looks like he might be using the facilities, so I apologise.
And I'll come back in 5 minutes once you're ready. No worries.
Your Excellency, we will now call Mr. David Youssef.
Engineer. Daoud Theodore Youssef, and I'm a consultant. I swear by the Almighty God, say the truth, the whole truth, and nothing but the truth.
Mr. Youssef, you should have a bundle of expert reports in front of you. Could you please turn to page 888 of the bundle, which is your expert report? See there a copy of your expert report.
I do.
If you turn to the end of that document, which you'll find on page 903, is that your signature?
That is correct.
And then if we go to the joint statement, which you will find, I think I've got it at tab 7, but I don't know whether it's the same in yours, but it's page 1400, 1400. Is that there, the joint statement prepared between you and Mr. Robin Ali?
Correct.
Good. And if we go to the third page of that, see there, page 1403, under the issues agreed and not agreed, you've entered an agreed position in the left-hand column, and then the middle column, or the third column, is that your expert opinion set out there?
That is correct.
And that goes all the way to the end of that document. And then we finish with page 1418. On the left there, is that your signature?
That is.
And those parts of the reports that I've shown you, can you confirm that those taken together represent your true and complete professional opinion?
It does, to the best of my knowledge.
Thank you. If you wait there, there'll be some questions.
Good afternoon, Mr. Youssef.
Good afternoon, Mr. Killen.
Mr. Youssef, in 2000 to 2009, you were the CEO of Good Health, weren't you?
2009. That is correct.
And Good Health has now been purchased by, is it Aetna?
That is correct.
Now, Good Health was a startup, wasn't it, when you joined it in 2000?
Not 100%.
It had about 3 million in sales, so it was relatively modestly sized, wasn't it?
That is correct.
And then I think in 2010, you joined Now Health, is that correct?
That is correct.
You were there until 2017.
Correct.
And Now Health was also a fledgling business when you joined it. It was a startup at that point, wasn't it?
True.
And that is a provider of health insurance, is it?
It is.
And Good Health was also a provider of health insurance. I think in 2017, when you left Now Health, you started Axios Consulting, is that right?
Correct.
And aside from speaking and arbitration witness experience, Axios primarily focuses on startups as well, doesn't it?
The combination of projects that we have done in the past few years.
And a core of your business is consulting with startups in the industry.
Not necessarily, no. Some of the projects we take are slightly outside the purview of health insurance. We also work with healthcare providers. Well,
And you're seen in the industry as a bit of an innovator or a disruptor, aren't you?
if that's what my peers say, take your word for it, sir.
Now, you haven't had any significant experience with insurers that are already established in the UAE, have you?
What context, if you can repeat the question, please?
I'm saying that over your career, you haven't had any significant experience with insurers who are already established in the UAE, have you?
Managing them, no, but many, many years ago, I used to be an insurance broker, so I was dealing with multiple health insurers in general within the market.
So many years ago, when you were a broker, you dealt with established insurers.
Yes, I did.
And you haven't advised any TPAs or established insurers as part of your work with Axios, have you?
In the UAE, no, but outside I have, yes. We had a project in Oman.
Now, I'd like to turn to the strategic partner model, which obviously forms a core of your report. Now, in your report, if you want to turn to it, it's page 891 of Bundle D. And at paragraph 15, you distinguish there between two types of TPA arrangements. One, you can see at 15A, which is what I would call a straight TPA arrangement. So a TPA entered into between an insurer and a TPA. And second, a corporate arrangement, which we can see at, sorry, the other way around, at A, where they enter into some sort of JV. Do you see that?
Yes, I do.
And it's important to differentiate between the straight TPA arrangement on one hand and the corporate arrangement on the other, isn't it?
That is correct.
Because in a corporate TPA arrangement, you'd need to take into account the fact that other insurers might perceive the TPA provider as being a creature of a competitor insurer, mightn't they?
That could happen, yes.
And that's important, isn't it? Because another insurer might perceive that that TPA in a corporate arrangement, by engaging them, they may be funding the profits of a competitor, mightn't they?
There is precedent in the market where there are certain TPA arrangements that are owned by, or either partially or in full, by by an insurer.
Understood, and we'll come on to those, but I'm talking at the general level here. There is a perception in the market, isn't there, that if you engage a TPA that is owned by a competitor insurer, you are in essence potentially channeling profit into a competitor, aren't you?
I wouldn't say channeling profits, but I would, I would assume that there would be a bit of apprehension in giving the business to the TPA. But, however, if I can clarify here, there's a lot of systems of checks and balances that you can put in there that can actually assist in managing that. And there are certain examples in both the UAE market as well as within the region.
Now, we'll come on to those. But another issue as well concerns data and client confidentiality, doesn't it? And a competitor may not want another insurer to have access to their information, mightn't they?
That would be one of the probably the things that will that could hinder that proposition. But again, like I said, there are always ways of preventing that, and there's plenty of examples. Because I mean, if I may just interject here quickly, the client confidentiality is paramount in our business, because we are in health insurance holding very important information, specifically medical, on behalf of many of the insured members and clients.
And because of these considerations, that's why you say, we can see it at paragraph 15, that it's important to distinguish between the two models of TPA, isn't it?
I mean, one and the other can go hand in hand, or you can have one of the models only. You can either be a partner in an insurer can be a partner in a TPA or hold shares in a TPA, and or you can have a TPA that has independent shareholders, and you just have a what we call a service agreement between the insurer and the third-party administrator or the TPA.
I understand that, but it's your words at paragraph 15, isn't it?
Correct.
The two different models are different, and it's important to distinguish between them. I assume you accept that, do you?
Yes, that is in my report, sir.
Now, you say here, and we can see at paragraph 15A, that you do not address the corporate TPA setup in your report. Can you see that?
Yes, I do.
15A in the brackets, which I do not address in this report.
That is correct. I mean, basically, if I can clarify, Your Excellency, basically here is I was never involved in the corporate structure. That's basically the meaning in my particular report here.
Now, I believe that as part of your instructions, you read the pleadings in this case, didn't you?
Sorry, can you repeat the question, please?
As part of your instructions, you read the pleadings in this case, didn't you?
I did.
And so you would have read the amended defense, wouldn't you?
Can you refer me to the document, please?
Of course. Well, we can see the list of the documents that you say you have read. If we turn to page 919. This is Schedule 1 to your report.
Okay.
These are the documents that you say you've read, and we can see at item 3, amended defense. Do you see that?
A long time ago, but yes, it's 2018.
So perhaps if we turn up the amended defense, that might help. If you go to bundle A, the amended defense starts page 14. You recognize that document? It has the green and the red and the black writing, the multicolored writing.
Yes, I did read it.
And if we turn to page 20 of that bundle, we can see this is paragraph 5D, and the transaction is set out little Roman numerals 1 to 5. Do you see that?
Transaction was broadly, is that the one you're referring to?
Yes, it is.
Okay.
And that says there, doesn't it, little Roman 1, that a special purpose TPA company was nominated to provide the claims handling and administration services. 2, defendant was to obtain a 51% shareholding. 3, GLOBEMED Limited to obtain a 44.6% shareholding. Then skipping to 5, the TPA company, the claimant, would then provide TPA services pursuant to the TPA services agreement. Do you see that?
I do.
So that is a description of what you describe in your report as a corporate arrangement, isn't it?
Most probably, yes.
So it is, in this case, that the relevant type of TPA arrangement is a corporate arrangement, isn't it?
Again, like I said, it is what my understanding of my purview of this particular report was not to look at the legality of it, but to look at the structure. And the structure was explained to me that there will be shareholding by an insurer in this particular entity. And that's what I meant by the corporate structure, that there will be an insurer shareholder within this entity. And that has happened in multiple jurisdictions within the UAE as well as the GCC.
Right, but I don't want to keep covering old ground. If we go back to paragraph 15A of your report, which is page 891 of bundle E.
Okay, I mean, again, like I said, the strategic partner model would be either, and in my particular report here, it says, either you can be a shareholder, but you would still have to have a service agreement or a TPA agreement, or you can be an independent insurer and still have a service agreement. And that is the two structures that I mentioned in my report.
I understand that, and it's the first structure that you set out at 15A that is relevant to this dispute, isn't it?
Partly, yes.
Okay, and yet it's that first structure which you say at paragraph 15A you do not address in this report?
I did not address the legality of it.
That's not what it says there, does it? It says you don't address that structure in this report.
Well, maybe English is not my first language, so maybe I misworded that.
And there isn't anywhere else in this report where you address the particular considerations that arise where you have a corporate TPA arrangement, is there?
I don't believe in my report specifically, but I think there is some mention in the joint statement.
That's correct, there is, and we'll come on to the joint statement. So your entire report is drafted on the wrong basis, isn't it? Because it's drafted not on the corporate TPA basis, but on the straight TPA basis.
Again, like I said, third-party administrator is the main part of a third-party administrator relationship with an insurer is the service management agreement between the two parties. The ownership is a legal issue, and that's outside my purview.
Now, in this case, it was a particular concern, wasn't it, of the parties that GLOBEMED was not perceived to be a creature of OIC. Are you aware of that?
I mean, that would be, again, in my professional opinion, that would have been one of the points, yes, that would have affected, or at least the purview of the market and the way the perception of the TPA would have been.
And if you stay in bundle E, and if you could turn to page 834. Now, this is part of the appendix to the report of Mr. Cottle, who is GLOBEMED's accountancy expert. You may not have read this. Did you have a look at this at the time?
I don't recall, sir.
Okay, well, I'll take you through it in that case. So you're on a document which was produced. We can go up 2 pages if you'd like to see the start of it, which is a proposal for relocation of GLOBEMED Gulf HS company offices. So it's a proposal created by GLOBEMED. And if we go down to page 834, we can see that there are some considerations. It says strategic considerations, and these are being put by GLOBEMED. And 3, it says take over current OIC offices. And you see in the right-hand column, point 1, offices well known in market as being OICs will significantly impede GLOBEMED's brand and will reinforce market perception that GLOBEMED is now an in-house TPA to OIC. Do you see that?
I do, sir.
And if we go down to the next page, there's option 3. And then in the third full paragraph, starting given that, it says, given that the market already believes G-Gulf has been purchased by OIC as an in-house TPA, it is my firm belief that moving operations long-term into old OIC offices, which are well known within the industry, will make that impression firm in the minds of the market. This will make it significantly harder to attract other clients to the company. You see, it was in fact GLOBEMED's express concern in this case that they don't be seen to be engaged in a corporate TPA arrangement. But you didn't take any of that into account in your report, did you?
It wasn't part of my purview, sir, no.
Now, moving on, you mentioned earlier about an example of some TPA arrangements. One of them you refer to in the joint statement is, I think, Cigna and NAS Neuron. Do you remember that?
Correct.
And I think there you suggest that the example of Cigna and NAS Neuron is an example of a corporate TPA, which you say was successful. Is that a fair summary of your opinion?
Yeah, if you can refer me, please, to these sections.
Of course.
Section.
So in the joint statement, if we turn to bundle E, so page 1413, so the start of this starts on page 11, which is or internal page 11, page 1410. See the question there. Is the likely success of GMGHS attracting significant additional business? Had the portfolio transfer from OIC taken place? And then at 1412, the last paragraph, you refer there to NAS Neuron, based in the UAE, which is currently majority owned by the health insurer Cigna. Does that help?
Yes, I can see that.
Now, in fact, Cigna is not a majority owner of NAS Neuron, is it? It owns about 30%.
That is correct, actually. That was an error on my part. Because, I mean, if I may, again, clarify, there is, and this is, again, market, not the exact market knowledge, I know it because I'm in the industry, there is discussions for Cigna currently to take over majority shares.
Understood.
Currently.
But those are just discussions at the moment, are they?
That is correct.
So where you don't have a majority ownership, the concerns about confidentiality are less, aren't they? Because there's no majority control.
That could be the case, yes.
And also, this ownership of NAS Neuron by Cigna, that was in around 2020, wasn't it?
Correct.
So it isn't an example of the model succeeding in 2015 to 2017, the relevant period, is it?
Again, I mean, I was just giving an example of some of the other entities that have shareholding within insurers that are successful. So it's not predicated that if you have a shareholding, or that TPA have a shareholding within as from an insurer, that doesn't mean that you will not be successful. That was what I was referring to here. And ultimately, I think the main issue for all of the insurers that will provide you with the particular outsourcing for is the confidentiality issue. And confidentiality, like I said earlier in my point, is paramount in this industry. If you breach confidentiality, then you don't have a business in a TPA model.
Now, there's also no data, is there, that shows that other insurers, other than Cigna, have in fact transferred business to NAS Neuron once Cigna took a 30% share in it, is there?
Actually, I haven't researched that portion, that part. I wouldn't be able to tell you yes or no. But I know for a fact that NAS Neuron is probably the premier TPA currently in the market.
Now, going back to your report, so moving away from the joint statement, back to page 891.
Sorry,
891.
891. Okay.
This is paragraph 16 of your report.
Okay.
Now, you address here what you say are the benefits of the strategic partner model. You describe them as a virtuous circle. Can you see that?
Yes, sir.
And you suggest that these benefits result because of growth. You say a total size of portfolio administered by a TPA grows, resulting in the following benefits, and then you list them at A and B. Can you see that?
Yes.
And then at 16A, you say for an insurer, the benefits are A, improved profitability, which permits lower premiums, and B, improved client service levels. Can you see that?
On the page, under 16.
16A, at the bottom of page 891.
Yes. Yes.
So of those two, profitability and client service, if we take profitability first, now you say that profitability rises if a TPA achieves better volume rebates and fee deals than an insurer. Is that right?
Theoretically, yes.
Or presumably they could also drive down operating costs, could they?
Correct.
Now, volume rebates, now they depend on your negotiating position, don't they? The stronger the position that you have, the more likely you are to get a volume rebate.
Correct. I mean, it's based on the volume of claims that you provide to the providers. And what you do is you negotiate with a healthcare provider like a hospital or a clinic. If you drive more clients and you have more claims spend, then what happens is you can negotiate a rebate back based on that volume.
Now, I'm not sure if you were in court earlier when Mr. Saliba was giving evidence. Were you here?
No, I was not.
Now, there was some discussion with Mr. Saliba about whether what drove the percentage of volume rebates was either the number of lives insured or the volume of claims. But I think it's your evidence, is it, that it's volume of claims?
I mean, they go hand in hand, sir. The more volume of lives insured you have, the more the claims you're going to end up paying, which ultimately drives their higher rebates.
Understood. So if a TPA has a large portfolio, then it may be able to negotiate better volume discounts than an insurer with a small portfolio. Is that the idea?
That is correct.
But presumably a TPA with a smaller portfolio than an insurer is unlikely to do better in those negotiations, is it?
Of course.
And presumably also a TPA, even with the same size or a larger portfolio, if they don't have, for instance, market familiarity, or they're not established, or they haven't been active for many decades, they would also be at a disadvantage, wouldn't they, in negotiating?
Again, it all depends on the expertise of the staff that they have working for them.
So, to put it another way, improved volume discounts are a possibility with a TPA, but they're far from inevitable, aren't they?
I mean, ultimately, that's how this market operates currently. I mean, if the model changes, then definitely things will change. But currently, this is how the model works. That the higher the claims volume, the larger number of lives, the higher the rebate. But there is always negotiations going on between TPAs, insurers, and healthcare providers. And that's, I call it a cat and mouse game.
And the cost to the TPA or to the insurer of providers providing services is made up of two parts, isn't it? Volume rebates on the one hand and tariff on the other. Is that right?
Excuse me, can you repeat the question, please?
Of course. So the total cost to an insurer of a provider's service is calculated by taking into account the volume rebate on the one hand and the tariff on the other, isn't it?
Correct. I mean, ultimately, the amount of claims that you're paying, then minus the rebate that you get back from them, equals your total cost of claims.
Understood. So if you had negotiated a particularly low tariff, say, with a provider, they would be less likely to give you a high volume rebate in addition, wouldn't they? Because they'd already be charging a fairly modest price.
I mean, again, that is between the provider, the TPA, and the insurer. So it all depends on how much negotiations and what ultimately transpires within those negotiations between the parties. So, and again, I can just throw in my commercial sense here, is it all depends on how hungry the parties are in terms, if the provider needs more business and they are already breaking even or making money, then they will go for lower, better rates and higher rebates. But again, theoretically speaking, your point of view is correct.
Now, do you remember we said that there were two benefits that you identified of the TPA virtuous circle? So one, profit, and two, client service. We move to client service. I think you suggest, this is at 16A, that there is improved client service which results from the TPA arrangement. Now, it doesn't necessarily follow that client service improves when you involve a TPA, does it?
I mean, again, it all depends on the processes and the systems of the particular TPA that you're dealing with. So if their process and their system is quality, then usually, yes, you do have an improvement because you have the volumes and you assume that there's a better expertise within the TPA because they're daily dealing with that particular, they're very specialized in that particular line of business.
Understood, but there are a lot of variables, aren't there? So the number of staff, perhaps, or the quality of the staff training, or the quality of the staff generally, or the effective claims management systems. These are all things that impact on the client service, aren't they?
Definitely, that's for sure.
And there's no reason why a TPA would be better at those things than, say, a dedicated claims team within an insurer, is there?
Again, I can't comment on that unless I'm hired to do the job on comparing between them, Mr. Stoker.
Understood. So it depends on a case-by-case basis,
Exactly,
doesn't it?
exactly. So,
and I think you also mentioned automated systems as being a benefit of the TPA model. Do you remember that?
yes,
Now, if a TPA uses an automated system, it might be cheaper, mightn't it? Because you would need fewer employees. Is that correct?
that's the, definitely that is part of the process, yes.
But it may not give better client service, mightn't it? People might not like the fact that their claims are automated rather than being able to speak to somebody one-to-one on the phone.
I mean, again, there's, if I may, there are different systems and different processes. You can have the front-facing side still customer-friendly. I mean, again, and where you have the TPA talking to the particular clients or the insured members. But on the, what I meant by, or one of the things about automating a process is on the claims adjudication side, that is linking the process, because if I may just clarify quickly about the industry, there are two things that you need in terms of managing claims. One is managing cost, and the second one is managing care, because at the end it is healthcare. So to manage the cost side is where the automated process works. That is basically where you actually, instead of having somebody manually review the tariff of the provider, the negotiated tariff, and looking at each and every claim manually, then what you do is you integrate the process and you integrate the systems. And then the system automatically checks the tariffs, checks the ICD, what we call the ICD coding, in terms of what the healthcare condition is versus the treatment, and it can automate that particular part of the process, but you don't really have to automate the front end, which is the customer service side. So,
understood. So it depends on what type of automated system, is that what you're saying?
correct.
Now, we know, don't we, that health insurance is, I think, the second most complained about type of insurance in the UAE, isn't it?
Frankly, I haven't seen the statistics, but
It's in your exhibit, but we can turn this. So if you go to page 1046 of Bundle E.
and 46.
So this was a document that you exhibited to your first report. And you see there's a table up in the top left-hand side. This is complaints classification.
Yes.
This was in 2017, a line of business, so it's at the end of what we're saying is the relevant period here. And we can see that health insurance is the second most complained about type of insurance. Can you see that?
After motor insurance, yes.
Yes. So if a cost saving results in less good service, and therefore there are fewer clients because they're complaining about your service, then in fact client service may not be a benefit of TPAs at all, mightn't it? It might reduce your portfolio size.
Again, it all depends on the quality of the people that you have and the quality of the system and the quality of your process. Ultimately.
Precisely. So it all depends, doesn't it? It's not necessarily a virtuous circle as you presented in your report.
And in my report, I said that customer service is only one aspect of the improvement. So.
And TPAs, obviously, they exist to make a profit, don't they? They're businesses that are profit making.
Definitely.
So if there are cost savings and there's an insurer and a TPA involved, then that cost saving has to be split between the TPA and the insurer, doesn't it?
That's part of the claims rebate that I talked about. That is split between the TPA and the insurer. But ultimately, in terms of when we say cost savings, even if the insurer is managing the claims in-house, they have an actual cost as well.
Of course, but if insurers can reduce a cost by themselves, by using their own automated systems, for instance, then there isn't actually an advantage, an inherent advantage of using a TPA, is there?
There is, because you have larger volumes. The TPA usually has multiple clients, not just one insurer. So you have what we call critical mass. And so when you look at the cost per claim or the cost per insured member, then ultimately that should be reduced because you have a larger portfolio.
Okay, so we'll come on to that now. So I think you're aware, aren't you, that at the time that this TPA was signed, GMGHS had almost no other lives of their own, did they?
I believe the numbers were 1,800.
Something like that, yes. I think that's my recollection as well. So if they had this very small number of lives, they didn't have any particular advantage in negotiating over OIC, did they? Because they essentially had the same size portfolio.
Not at that time, no.
Now, I'd like to move on to the growth that you say that GMGHS would have achieved. Now, starting first with the geographic location of the growth, I think it's your opinion in your report that you say the growth would have primarily been in Dubai, and that's because of the new compulsory health insurance law. Is that correct?
Partly, yes.
If you'd like to turn to it, you address this at paragraphs, starting at paragraph 21 of your report on page 893. And the health insurance law that you refer to there is the health insurance law number 11 of 2013, isn't it?
Correct.
Now, I think you make the point, this is at paragraph 21b, that in Abu Dhabi, where the compulsory health insurance law was already in place, it would have been harder to achieve significant market penetration. Do you see that?
I do.
Now, in fact, the rollout plan for the health insurance law in Dubai meant that employers with over 1,000 employees already had to have their employees insured by October 2014, didn't they?
Correct.
And I think it was the end of July 2015, which was the deadline for those employers with between 100 and 1,000 employees, wasn't it?
Correct.
And I think everyone else, the deadline was the end of June 2016, wasn't it?
That's what the law stipulated, yes.
Now, I think you yourself note that GlobeMed would not have sought non-OIC business until early 2016. Do you remember that?
Yes, and I believe that I was relying on the witness statement of Mr. Roger Saliba.
That's correct, yes. And in fact, we'll turn to that very briefly. So it's at page 350 in Bundle D, and it's paragraph 115. You can see he says, I consider that GMGHS would then have focused on bedding in and servicing the OIC portfolio for the remainder of 2015, and would therefore not have actively sought to win additional TPA client business, i.e. non-OIC, until January 2016 at the earliest. Do you see that?
Yes.
So at the very earliest, we're looking at January 2016, when GlobeMed's going to start looking for this non-OIC business, and that's on GlobeMed's own case. And it's right, isn't it, that an insurer needs a few months of run-in to transfer its portfolio to, say, a TPA, doesn't it?
For sure, that's what we call the transition period.
And so by early 2016, the vast majority of employers in Dubai would already have their insurance arrangements in place, wouldn't they? Because they'd need to get them in place to be ready for June 2016, wouldn't they?
The insured members, yes.
So, in fact, if GMGHS weren't looking to get new business until at least, at the earliest, January 2016, they were far too late to take the benefit of the health insurance law, weren't they?
I wouldn't say that, but I would say is that there was a trend, as you can tell from my joint statement, for insurers to transfer, because we're not talking about just insured members here. We're talking about the TPA market in general. And the growth was in the TPA market because there was a trend during that period of time for insurers, who are ultimately the clients of a TPA, to transfer their business to be administered by a TPA. So that is what I was referring to here in terms of growth.
Understood. But it's your own evidence, isn't it, that it would have been more difficult in Abu Dhabi because the health insurance law was already in place. So presumably the same would apply to Dubai if the health insurance law was already in place.
In Abu Dhabi, it had already been in place for a few years. So the market saturation was already achieved. But in Dubai, the market was still in flux. The law was new, and the insurers and the TPAs were still trying to find their footing in terms of what's the best way of administering and servicing the volumes that were coming in.
But an insurer, if it had been ready to accept all of these numbers between 2015 and 2016, and it had them in place, as I think you agreed with me, by early 2016, it's not going to then immediately, in 2016 and 2017, switch to a new TPA, is it? There'll be minimum terms, and the run-in period will take a while, won't it?
It all depends on the negotiations, yes, and in terms of bringing on board these insurers.
Now, in mid-2015, I think there were 22 active TPAs in the UAE, weren't there?
I believe so, yes.
And of these, I think just 6 controlled about 80% of the market, didn't they?
Yes.
And I think of those 6, just 2, NextCare and NAS, I think they held about 50% of the market, didn't they?
That is correct, yes.
And I think you agree, don't you, to the fact that it is in essence a bit of an oligopoly in TPAs, with some very large ones at the top that control the majority of the market?
I mean, again, these are the ones that had the volume that were able to provide the economies of scale and the critical mass and the negotiating power. And again, I would had put GMGHS up there because with the acquisition of the OIC portfolio, they would have been definitely in the number 3 position, and probably by 2018 with 600 some thousand, had the whole portfolio transferred, they would have been in the number 2, probably 2, 3, or even number, they would have challenged for the number 2 position by then.
Understood. But as we've already covered, this would be a situation where OIC was a majority owner of GMGHS, and it would be in a situation where the portfolio that GMGHS has is no bigger than OIC, isn't it? We've covered that already.
In which year is that, please?
In 2015.
2015, yeah, because according to Mr. Roger Saliba's statement, they wouldn't be going after new business during that year.
Now, I think that 2 new TPAs did break into the market in 2016, didn't they?
I believe they were around, but they broke into a different model, I think.
And the different model you're referring to, that's the price cap model, isn't it?
Correct.
And just to explain, that model occurs, I understand, where a TPA agrees that the amount of claims paid won't exceed a certain price, and anything they settle under that price, the TPA keeps as profit, and anything that settles over that price is then taken as a loss by the TPA, so the insurer knows its exposure. Is that right?
It's known as the capitation model.
Capitation model, thank you. Now, the capitation model wasn't the model that GNGHS used, was it? They used a traditional percentage model.
As far as I know, yes.
So there were no TPAs during the period, new TPAs that broke into the market using the same pricing model as GNGHS, were there?
At that time, no, because again, they didn't have the critical mass that we were talking about here. If they had acquired the OIC portfolio, again, according to my professional opinion, they would have had the critical mass and the volume to negotiate. But no other TPA at that time managed to acquire a large portfolio, according to my knowledge.
Now, I think you give in your report some examples, and I'm sorry we're skipping back a bit here at paragraph 13, 13A to C, that's page 891 of your report. And you say that these are examples of TPAs who have successfully implemented the strategic partner model. Do you remember that?
Yes.
So starting then at 13A with Orient Insurance and NextCare. Now, NextCare is owned by Allianz, isn't it?
Correct.
And Allianz is a major reinsurer of Orient, isn't it?
Partly. According to my market knowledge, Orient uses other reinsurers as well.
So when Orient has its claims managed by Allianz's TPA, it is also likely, in many occasions, getting reinsurance support as well, isn't it?
For that particular portion of the portfolio, I believe that NextCare manages, yes. Again, this is purely based on my professional opinion, my market knowledge.
Understood.
I don't have any inside information.
Of course, understood. And so if you were to try and entice Orient to move their portfolio, you would need to have an offering that had not only TPA services, but likely also reinsurance services as well, wouldn't you?
Again, it all depends on what Orient's strategy is.
Now, I don't think there's any evidence in your report or in the documents that you have filed as to the number of non-Orient lives that are being serviced by NextCare, is there?
Sorry, can you repeat the question?
I don't think there's anything in your report as to the number of non-Orient lives that are being serviced by NextCare, is there?
No, but I know that there are multiple clients that they have, multiple insurers, aside from Orient.
Understood, but that's not in your report, is it?
That is not in my report, no.
So without that information that we can analyse and assess, we can't know if the strategic partner model has worked, can we, for Orient and NextCare?
I mean, again, I will rely on my professional expertise, and like I said, I've been in this in the industry in the UAE for 30 years plus now, and I've seen the growth of the health insurance market. So, based on my expertise and my knowledge of the market, I have seen that at the time NextCare started, Orient was their first client that was large enough to be able to catapult them into the next phase. Again, that's based on my knowledge of the market.
So that's your assertion. You haven't put anything in your report that backs that up, no figures, no information.
That was, I mean, again, like I said, I don't have any inside information. So, but I have a good knowledge of the market.
And the next example at 13B that you refer to is the government of Dubai and Neuron.
Correct.
Now, again, there's no evidence of Neuron's split between the government of Dubai and other lives, is there, in your report?
At that time, no.
And Al Watania and Al Wafba and NAS, they're both Abu Dhabi insurers, aren't they?
Excuse me?
Al Watania and Al Wafba, they're both Abu Dhabi insurers, aren't they?
That is correct, because and the NAS was mainly Abu Dhabi focused TPA at the time.
And neither Al Watania nor Al Wafba have a significant percentage of the Abu Dhabi market, do they?
They don't individually, no. But as far as clients of NAS, yes, they would have, NAS would have held a significant proportion of that business.
Understood.
When it comes to them as a TPA.
Understood. Now, I think when you were looking at the strategic partner model, you described it as being involved with a major insurer, and so neither Al Wataniya nor Al Wathba satisfy that definition of being a major insurer, do they?
Major insurer, as far as the TPA is concerned, is based on the volume of the number of lives. So it'll be major for the TPA. Doesn't have to be the largest insurer, because when it comes to health insurance, for example, right now, Orient is the number one, but at the time, I believe Daman was the number one insurer in the UAE when it came to health insurance.
But as I understood it, your evidence was that the benefit of a TPA was in having a large portfolio and being able to negotiate good fees, tariffs, and volume rebates as a result.
Correct.
So you need a large percentage of the market, don't you? You need an absolute number of lives before you can take the benefit of that portfolio, don't you?
Absolute, can you define absolute?
You need a large number, a sufficient number of lives.
A large number, it depends on the market.
So when you talk about a major insurer, you're talking about a major insurer in the market, not a major insurer for the TPA, aren't you?
I'm talking about the numbers that give you the critical mass, basically. And in this particular case, both of these insurers did give NAS a critical mass.
Over the page, 894, 23B of your statement.
Sorry to interrupt. I'm just worried about a short break for the...
Of course.
We're going to finish by 4. Are we going to extend that a little bit, or what do you think?
I may go a little past 4. I have just finished a topic, so if we wanted a short 5 or 10 minutes...
I think it's the right time to have a 10 minutes break, not too much for you.
Thank you, Your Excellency. Mr. Youssef, I've just taken you to paragraph 23B, which is at page 894 of your report. Do you have that open?
Yes, sir.
You say about midway through that paragraph, you say, I do not think that it is controversial to say that by 2019, the Dubai health insurance market had seen the predicted growth. And by then, more than 98% of the health and medical insurance market was outsourced to TPAs. Do you see that?
I do.
If we can just move on to paragraph 29 of your report, which is page 896. You say there, absent any published statistics for TPA usage or market penetration within Dubai, I have estimated below the approximate percentage of Dubai's insured population that is being managed by TPA service providers each year by applying my knowledge of the TPA and Dubai healthcare markets at the time. Do you see that?
I do.
And then the results of those estimations are in the table below paragraph 30, staying on the same page. And you see under 2019, assumed percentage of the market using TPA's percentage, you've done 80%. Can you see that?
I do.
So at paragraph 30, you've estimated it at 80%, but at paragraph 23B, you estimated it at 98% for 2019, didn't you? Those two numbers can't both be correct, can they?
Correct. I will clarify as to where these figures came from. The 98% came from a report by the Dubai Health Authority, which when I referred back to it and I looked at the market, and what we do is sometimes in our business, we do something called triangulation. We look at multiple sources of information, because sometimes the real figures are not published 100%. So we try and triangulate, and that's why in my projections, I took out the insurers that I know were managing the business in-house. And so I took that number out and I came up with the 80%, sir. So yes, I believe, and I didn't want to say that the HA was wrong, but basically I did some re-crunching on the numbers.
Understood. So we should delete that sentence, should we, at 23B, when you say, and by then more than 98% of the health and medical insurance market was outsourced?
Yes, that is not correct. But again, we can always debate the actual number because there are no 100% published figures that we can, and the best way to do it is to look at the total market and do triangulations, multiple sources here.
Now, I think we said earlier there were 23 TPA providers providing services in Dubai at about this time, so 16, 17. Is that correct?
Correct.
And so if you wanted to know the percentage penetration of the TPAs into the healthcare market, you would need to know first what each of those TPAs was doing, and second, the number of insured lives in Dubai, wouldn't you?
Correct.
And neither of those figures are available from a reliable source, are they?
If I had looked at some of the reports, and if in my report I have referred to some of the sources that I've used, sir.
Understood. But these are essentially, as you say, your estimates applying your knowledge, but they're not based on data, are they?
Repeat the question in terms of the population of Dubai, or is it the TPA population?
In terms of the number of insured lives and the percentage of those insured lives being managed by TPAs?
It is to the best of my knowledge, based on my professional expertise and the knowledge of the market.
Now, turning over the page, 897, this is 32, you split TPAs into Tier 1, Tier 2, and Tier 3. Now, these, I think, are also extrapolated from your estimates and your knowledge, and you've given 42%, 39%, and 20%.
There actually, I should have referred that, but there is a report by the Dubai Health Authority that mentions these particular figures. That's what that's what I relied on.
Okay, and I'm sorry, you're quite right. I think footnote 9, you say that.
Yeah.
Now, you were saying that another thing that you based it on, I think, were population size. And I think you say that there are no insured figures for the population in Dubai for 2016 and 19. And so the table, I think, at paragraph 28, which is at page 895, you've used an estimated insured population number. Can you see that?
895, sorry, just give me a minute, please.
It's table 1, just underneath paragraph 28.
Yes, and actually it turns out, after having the discussions with my colleague, Mr. Ali, the expert witness for the defendant, we underestimated these figures. Turns out that there was 4.1 million insured by visa holders of Dubai.
So I saw that in the joint statement, but if we just take, for instance, if we have a look at 2017, you've estimated an insured population number there of 2.758 million. Can you see that?
Correct.
Now, I think 2017 is one of the few years that we do have an insured population for. This is in your exhibit to your statement. If you turn to page 975 of Bundle E. Up in the top left, can you see, we can see health insurance in Dubai, demographics, and it says there 2.4 million insured population. Can you see that?
I do.
And so, in fact, although in the joint statement you say you underestimated the population, it appears from the DHA published figures that you have overestimated the population, haven't you?
Like I clarified earlier, there's no one specific source that you can rely on for 100% accurate data. So you try and triangulate and look at multiple sources. Because if you look at what the DHA had said, that there's, by 2017, you had almost 100% of the population insured. and you had 4.1 million population. So these figures sometimes don't make sense. So that's why you don't rely on one source to be able to look at the information.
But the fact is, we just don't know what these numbers really are, do we? You're having a guess, aren't you?
Again, like I said, it is a matter of looking at multiple sources and trying to find the best and the most conservative formulas to be able to come up with the approximation. Yes, it's not 100%. It is approximation, but I believe they are good approximations.
And so your best approximation, as I understand it, for, say, 2017 was 2.758 million. But I think you now say you think it's 4.1 million, and the DHA say it's 2.4 million. Now, that's an enormous range, isn't it?
That's for sure.
Now, it is important that we have accurate figures for these numbers, isn't it? Because unless we know what the insured population is, and unless we know what percentage of those insured lives are managed through a TPA, it's very difficult to assess the market that GMGHS would have been competing for, isn't it?
Again, it's based on the most accurate or the most conservative projections that we were able to get our hands on in terms of data. Sorry.
Now, I assume that you're familiar with fronting or cedant arrangements, are you?
Reinsurance arrangements, yes.
That's where a local insurer issues a policy on a risk that then cedes all or nearly all of the risk back to a reinsurer, correct?
Correct.
Now, I think you know that when there's a fronting arrangement, the international reinsurer invariably manages and administers the claims themselves, don't they?
Depends on the model. There are actual different examples where some do and some outsource to a TPA. Or some actually have the cedant insurer do it for them.
But the most common, isn't it, is for the reinsurer to themselves manage the claims?
As an international insurer, you mean?
Yes.
A brand, is it?
Well, no, because they're in a fronting arrangement, so it looks to the insured, unless they look closely at the policy documentation, that they're insured by the local insurer, but in fact it's the reinsurer that is managing the claims in the background, isn't it?
I mean, if it is one of the, if you are referring to somebody like a BUPA, for example, then usually, yes, they retain most of the control.
And so you would need to take these fronting arrangements into account when you are calculating the likely percentage of insured lives that would be managed by a TPA, wouldn't you?
Correct.
And likewise, I think when foreign insurers are present in the market, they almost always also process claims in-house, don't they?
I have examples where they're actually outsourced to TPAs, and I can give you refer you to another example of Allianz Worldwide Care, which is outsourced to NextCare. It's managed by a TPA. I can refer you to Cigna, where the claims are managed by Neuron, another TPA, as well as Aetna, which is managed by Neuron. So there are multiple examples. There's another example where I used to manage Now Health, that they have set up a TPA and they manage their own claims through that TPA. So it all depends on the model. There are different models within the market.
But the majority of foreign insurers manage the claims themselves, don't they, rather than through TPAs?
In the UAE or outside? Again, you have to...
In the UAE.
The majority actually don't.
You disagree with me on that?
Yes.
But I think you would accept, wouldn't you, that there is a percentage, not a majority, but a significant percentage that manage their own claims in-house?
In-house, I don't know of any that is, I mean, again, we have to start here arguing semantics in terms of legalities. So none of them that I am aware of are licensed locally to be able to manage their own claims.
Now, assuming I'm right, so I understand you disagree with me, but assume for the moment, in a hypothetical, that I'm right, that international insurers are more likely to manage their own claims, you would need to calculate and take into account the percentage of the UAE healthcare insurance market that was underwritten by foreign insurers, wouldn't you?
I would assume that the Dubai Health Authority figures and any figures we relied on in terms of the regulator, the insurance regulator, that those figures are already built in because they are already assumed to be insured by the local insurer. And they're just reinsured back to these international insurers. So as far as the UAE is concerned, these numbers should already be in the statistics already that we've seen.
I'm sorry, just to clarify, is it your evidence that when the DHA classifies an insurer as a foreign insurer, they take into account fronting or cedent arrangements?
Okay, I mean, there is, I mean, I think we're kind of slightly off page here. There are international insurers that are licensed currently, and I can give you an example of MetLife, for example. They manage their own claims in-house until recently, where they've outsourced to a TPA. But there are also international health insurers that are fronted locally. So there are two types of international insurers in the UAE. There are ones that are licensed locally, and they have their own offices. Two of them that I can think of that work in health insurance are MetLife and Cigna. One manages, was until recently managing their claims in-house. That's MetLife. And Cigna has outsourced to Neuron NAS.
Can we just turn, this is within your exhibit, to page 1051 in Bundle E. The first page of this document is 1040. It's the Insurance Authority Report 2018.
Page 1051?
1051, yes.
Okay.
And we can see up in the top left-hand side there that there are lines of business.
Okay.
And we can see total health insurance. And let's take 2016, for example. There was a total of, I think, 17.1 billion dirhams, of which foreign companies represented 4.7 billion dirhams.
Correct.
Now, those foreign companies, they are foreign companies writing business in the UAE in their own name, aren't they? That doesn't include fronting arrangements.
Correct.
And that's about, I've done the maths, and I think it's about 27% of the market, isn't it?
I don't have a calculator in front of me, but yeah, I would assume you're correct, roughly.
So, and again, I understand you don't agree with me, but you did just give me the example of MetLife. If I'm right, that international insurers, foreign companies, are more likely to manage their claims in-house, then you would need to make a significant reduction to the likely total percentage that are run by a TPA to take account of the number of foreign insurers operating in the Dubai market, wouldn't you?
Again, looking at this particular table, it's a lump sum, so I can't give you a yes or a no or figure answer because the largest one is MetLife, but all of the others that I'm aware of are being managed by a TPA. So if you extrapolate from that, then I believe the figures are still correct because not all international insurers or foreign insurers, as per this, do their own. And there are a lot of foreign insurers that are, I can think of New India or some of the other Indian insurers. They actually don't manage their claims in-house. They're all outsourced to a TPA. So not all foreign insurers do manage their claims in-house. The largest would be MetLife out of those examples. But all of the majority of the others are not very large, and as you can see from the statistics here, in terms of health insurance.
Now, the fact is that the assumptions that you've made, the estimates at paragraph 30 of the percentage of the market using TPAs are likely to be overestimates, aren't they? The TPAs are likely to be less than that when you take into account all of the percentages of the market that don't likely use TPAs.
You mean in 2019, 18, 17, any specific year, or?
16, 17, 18, and 19, as you've got at paragraph 30.
Yeah, I mean, 16, I did 50%, which I think is ultra-conservative, 60% in 17, 70% in 18, and 80% in 2019. So, again, triangulating and looking at multiple sources, I would stand by these numbers.
But we just have to take your word for it, don't we? Because we can't interrogate those multiple sources ourselves. They're not there for us to look at, are they?
I was asked to come here because I am an expert in this particular market.
Now, another thing I think you were asked to look at was fee structures and profits for TPAs.
Not the profits, actually. I was asked to look at the fee structure.
Now, there are two types of plans, I think you refer to, a basic plan and a premium plan. And
Right.
Just so I understand, the basic plan, is that what you use to describe the mandatory minimum required by the health insurance law?
That plus it only applies to employees that earn below 4,000 dirham salary, or the LSB we call them, low salary band.
And the premium plan, that's everything that offers something beyond the minimum, is it?
That's for people that earn above 4,000, we call them enhanced plans.
Now, the profit margins in basic plans are very low, aren't they?
Correct, because the premium is very low.
And that is because they're fixed to some extent by the DHA, are they?
Yes, correct. I think I mentioned there's a range that the DHA had set in the law, where you can only charge between a certain range of, I believe, 520 and 730 dirhams annual premium.
So the most significant premiums that we need to know about in order to calculate profitability are the premiums for the enhanced plans. Would you say that's correct?
Correct, but there are large numbers as well in terms of the basic plan. So
I think at paragraph 41 of your report, page 899.
41?
41, yes, page 899. You talk there about the enhanced plan. You say it varies depending on the grade, rank, or title of the employee. In 2015, the average single premium for an enhanced plan, also referred to as a premium policy in Dubai, was in the region of 2,000 dirhams per person per year. Do you see that?
I do.
You haven't cited a source for that figure, have you?
The source is my own knowledge of the market.
Very round number, isn't it? 2,000 dirhams.
It's an average, so.
Obviously, to calculate an average, you need to know all of the costs for all of the plans and the number of the plans, and then you divide them, wouldn't you? That's the type of average. You're talking about a mean, or?
I'm talking about, according to my knowledge, in terms of yes, it's usually the mean, you're right. It's the bulk of the plans that were being sold were the enhanced, what we call local plans.
We can't check that figure of 2,000, can we? Because you haven't given us all of the premiums, charges for all of the numbers and for the number of lives.
I did not do that exercise.
Now, I think we know from Mr. Saliba's evidence that the TPA market was tough. Did you review the transcript of his evidence from the first day? Sorry, from the second day? So not this morning, but Friday.
From Friday, I did. I actually did read it, yes.
So do you remember he told the court on Friday that the TPA businesses are, and I think this was the quote, most of the time loss-making during the first years of operation? Read that bit.
I don't recall, actually.
For the court's note, that's day 2, page 174, lines 14 to 15, Your Excellency. Now, so it's Mr. Saliba's evidence that the TPA business was tough and it was normally loss-making in the first years. We also know that the margins in healthcare insurance generally were very tight, don't we? That's something you address in your report, don't you?
They are usually when it becomes a more mature, saturated market, yes.
You say at paragraph 42, combined ratios of healthcare businesses were reported as 101% in the UAE. Can you see that?
Yes,
And that comes from the Insurance Authority annual report, does it?
correct.
Now, I think, in fact, the Insurance Authority annual report says 100.1%, doesn't it? Not 101%.
I will take your word for it, sir.
Certainly, we can go to it if you want, but you take my word for it. But anything over 100%, just to be clear, that means that an insurer is paying out more in claims and costs than it takes in premium. So essentially, it's making a loss. Is that right?
Correct.
Now, I think you say, and this is paragraph 44, the bottom of the page, 899, that TPA service providers charge between 5% to 10% of gross premium.
I see that.
You see that? Now, I think expenses for insurers are between about 9.3% and 12.3%, aren't they?
All depends on the type of insurer, the volumes, their efficiency levels. I will not be able to comment on that. But
Now, I think you've put something in your own exhibit that has this information in it. But we can turn to that, page 1054. Your Excellency, just by way of update on timing, I think I should be done by about past, if the court is willing to indulge me until then. I don't know if
There's
Mr.
no any further.
Claimant, no.
So we look at page 1054. This is the Insurance Authority report. Top left, health insurance in the table. And you can see expense ratio, and it's split between group health insurance and individual health insurance. Do you see that?
yes,
And so it's 9.3% for group health insurance and 12.3% for individual.
correct. That's what it says here.
So those are the expenses that the insurers were incurring, and at that level, they were making a little bit of a loss. Now, some insurers, or I suppose all insurers, would still incur some expenses, even when they're using a TPA, wouldn't they?
Correct. Yes. I mean, definitely they'll have an overhead that they need to manage.
So they incur the costs of the TPA, but also their own expenses. So if a TPA was charging 10%, so the top of your range that you suggested was reasonable, then insurers would be making even more of a loss, wouldn't they? Because they'd be paying 10% to the TPA, incurring their own costs. And we know that at 9.3%, they were already making a loss.
101%, according to this, yes.
So the amounts that a TPA can reasonably charge is significantly less than the 10% at the top of your range, and it's likely less than the 7% that you've estimated at paragraph 45, isn't it?
Again, it all depends on the negotiating power, the number of lives in terms of, and the type of services that they've negotiated between each other.
Now, by the end of 2017, employers started decreasing the insurance packages available to employees as the premium costs rose, didn't they?
That is correct. There was, like I said, and I believe, mention that in my report, that there was a downward pressure on premiums, and that that actually incorporates, downward pressure on everybody's margins at that time.
The fact is that the margins in health insurance were simply very, very tight, weren't they?
They always have been.
Because the TPA industry is parasitic upon the health insurance industry, the margins in the TPA industry were also very tight, weren't they?
They were reducing, and again, I mentioned that in my report.
Now, in your report, I think in the joint statement, you refer to Q80 situation, and you refer to the anchor client model or the strategic partner model being used in Q8 as an example of why it might have succeeded in the UAE. Do you recall that?
I do.
Now, I think in the joint statement, you say that the figures speak for themselves. I think that's at page 1403, if you want to have a look at it. The Q80 or the Q8 data referenced at Mr. Saliba's first witness statement speaks for itself. Now, on a bit in the joint report at 1407.
1407?
Yes, 1407. You refer there to agreement with Mr. Ali on the point made at 4.1.6, which is differences between the Q80 and the UAE market. But you say the insurance market does have some resemblances to the UAE market, as it is dominated by a few large local insurers. Now, in fact, Q8 has a much smaller percentage of the population insured with health insurers than the UAE, doesn't it?
Correct.
I think in 2018, it was about 12.5% of the size of the UAE market, wasn't it?
In terms of number of lives insured, is that what you're referring to?
Number of lives insured.
I would assume so, yes. Because there is no compulsory health insurance law in Kuwait.
And there were a very small number of TPAs operating in the market compared to the UAE, weren't there?
Correct.
But it's quite difficult to draw comparisons between Q8 and the UAE, isn't it?
In terms of market, probably, but my main reference here is to the strategic partner model. That within the Kuwaiti market, sister company of GMGHS, GLOBEMED Kuwait, did actually manage to get an anchor client and then grow the business as we mentioned in these statistics here, from 992 lives to over 112,000 lives.
But the likelihood of success of that model requires you to replicate the situation, the market as it was in Q8, in the UAE, and they just aren't comparable, are they?
Again, we're referring here to the critical mass. We're looking at critical mass, and the OIC portfolio would have, had it been acquired by, and again, this is my opinion, by GMGHS, they would have had the critical mass to be able to catapult themselves to the next phase, and that is we're able to negotiate better rates, better deals with providers, and attract other clients within the market.
In fact, a better comparator than Q8 would have been to see how GLOBEMED actually would have performed using a strategic partner in the UAE, wouldn't it? If that information was available.
If it was available, but it wasn't.
Now, I think you also mention in the joint statement the market in the Kingdom of Saudi Arabia, and you say that GLOBEMED has been very successfully operating in the KSA market since about 2004. That is, I think, as well at page 1407. I don't know if that's still open in front of you, is it?
Yes.
Now, there's no underlying data which you refer to or exhibit to support that assertion you make in that paragraph there, is there?
It's based on my knowledge of the Saudi market. And I believe that GlobeMed in Saudi, or GlobeMed Saudi, manages over 1 million lives. Saudi.
And you don't say in that paragraph that GlobeMed used a strategic partner model in the Kingdom of Saudi Arabia, do you?
I do not mention that, no. But I believe they did.
Your Excellency, if I might just have 1 second to take some instructions. Very much, Mr. Youssef. Your Excellency.
No re-examination from me, Your Excellency, so unless you have any questions for the witness.
Thank you, sir.
This case, tomorrow, going to have...
The defendant's industry expert, Mr. Robin Ali, will come in.
for the full day.
No, I would expect for about half a day until lunch, I would hope. And then we will move on to Mr. Cottle, who hopefully will get on in the afternoon in time to move to Mr. Burrows, well, who knows, but possibly Wednesday.
Thank you. Appreciate it.